This House is in session. Minutes of the meeting held on Tuesday, July 23rd, 2024 to be deferred. Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be deferred.
The question is that the aforementioned minutes be deferred. All those honourable members in favor, please say aye. Those against, please say no. Methinks the ayes have it. The aforementioned minutes are hereby deferred.
Messages from Her Excellency the President. Petitions, papers.
Honourable Leader of Government Business.
Mr. Speaker, I'm commanded to lead the annual report and audited financial statements of the Barbados Port, Inc. for the year ended March 31st, 2023, as well as the audited statement of accounts of the Board of Management of the Lodge School for the year ended March 31st, 2022.
Government notices. Private members' notices. Notices of questions. Report from select committees. First reading of bills.
Honourable Leader of Government Business.
Mr. Speaker, I beg to move the first reading of the Bail Bill 2024 and also the first reading of the Foreign Currency Permits Bill 2024.
The question is that the aforementioned bills be read a first time. All those honourable members in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Leave of absence. Oral replies to questions. Notice of motions for the adjournment of the House on matters of urgent public importance. Orders of the day.
Honourable Leader of Government Business.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42 subsection 5, 43, and 44 for the remainder of the day's sitting.
The question is that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favor, please say aye. Those against, please say no. Methinks the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business.
Government business is the order of the day.
Number 9.
Yeah.
Order number 9, sir, on the supplementary order paper. We will now read, enable the Honourable Attorney General to move the second reading of the Bail Bill 2024.
Honourable Member for St. Joseph.
It is always risky, I suppose, to assume or even to presume that matters of governance will see both the opposition and the government marching hand in hand. We are treating this bail bill, as an urgent matter. And I remind the Chamber, of course, that in recent public statements made by the Leader of the Opposition, he is reported, I should say, in the press to have made a call for an urgent amendment to the Bail Act for the purpose of preventing people who are charged with murder from getting bail. That is, I accept a paraphrase, but I think the essence of the Leader of the Opposition's call was for us to amend the Bail Act to stop people charged with murder from getting bail. This call, I believe, was made only 3 or 4 weeks ago. I would assure him, of course, that we are not marching to his drum or to the beat of his drum. But we accept, as a government, that on matters relating to crime and violence, law enforcement, things of that sort, all political parties have an interest. Government, for the purpose of safeguarding the citizen, ought not to be seen as a blood sport between the government benches and the opposition benches. I am grateful for those people who felt it was necessary to post in the last few weeks many of the statements that I made about crime and violence when we were in opposition. Mr. Speaker, I stand by what I said then. They didn't post the parts where I said that the opposition, as we then were, stood ready to work hand in hand with the government, as it then was, on matters of crime prevention and de-escalating what was happening in our country, because it could not be treated as a political football. Time and time again, when we were in opposition, Mr. Speaker, we called for the government to sit with us. Not because we stood from any position of intellectual or other superiority, but because we too represent constituents inside of Parliament and outside of Parliament. And as an opposition party then, we felt that if nothing else, a government and opposition should at least be able to come together and work in the interest of all Barbadians. You know, Mr. Speaker, people talk about agencies of government and BLP people getting the jobs and DLP people can't get none. They talk about all of the perceived instances where there is some kind of advantage to be gained because you support one side over another. I have never heard anybody say that a criminal decides who to shoot, or where to rob, or who to do harm to, based on anybody's political stripes. In that regard, sir, criminals are equal opportunity people. They have no interest in whether you are a B or D. They have an interest only in securing what they want from time to time. So in a way, Mr. Speaker, I am very happy that the Leader of the Opposition sought to speak on the matter of amending the Bail Act to prevent murderers from getting bail. I was, however, a little bit surprised because in 2019 we had already done that. And in 2019, though mentally the Leader of the Opposition may have left our benches, physically, when he moved the Bail Amendment Act that day, he was sitting down right behind me. His eyes would have been fixed on my scalp. And in 2019, after much discussion, after briefing the parliamentary group, of which he was then a party, we said that we had to grapple with this issue of the revolving door that was bail, and that notwithstanding that there could be constitutional challenges, his favorite bailiwick now, that's his favorite umbrella, you waiting to hear him today on it. Notwithstanding that there could be constitutional challenges, we felt that it was important in the safety of Barbadians, important for the safety of Barbadians, to amend the Bail Act and provide in that 2019 amendment that a person who was charged with murder, treason, high treason, or firearm offenses could not get bail for 24 months. I have no explanation why the leader of the opposition did not have that fixed in his brain. But if nothing else, his public comment suggested to me and suggested to all of us that in his view, something needed to be done about the bail situation in Barbados. And on that, there is no light between us. Something needed to be done. So I will be charitable to the leader of the opposition and say that, forgetting that you were on this side when we passed the amendment, we agree that something needed to be done about bail. And the reason for this, Mr. Speaker, is because our bail amendment that we passed in 2024, and I believe Hansard, when you look back at it, will show, because it was passed in accordance with Section 49 of the Constitution, it will show that the honourable member of the opposition, when polled, when his name was called, said yes. He doesn't say aye, not in here. He may say aye in George Street, but not in here. In here he says yes. And Hansard will report the honourable member said yes to that amendment. So I hope, Mr. Speaker, and I'm not begging him for anything, but I hope that he will see today's urgent debate as being a step in the direction that he, too, wishes we would go in. But I digress, Mr. Speaker. I was just pointing out to the chamber that the amendment that we passed in 2019 was struck down by the High Court. I remind the country, I remind the chamber, that that amendment said if you were charged with murder, let's forget treason and firearm, not treason and high treason. I'm not going to make any mention to them again in this debate. If you were charged with murder and firearm offenses where you could get more than 10 years imprisonment, you could not be granted bail for 24 months. The constitutionality of that was challenged, and the 24 months. The constitutionality of that provision was challenged, and the court at first instance ruled that it was unconstitutional. The court held the view that while there may be issues with crime and violence in the country, it was not open to us as a parliament to remove from the discretion of the judge the granting of bail in any shorter period. I don't agree that the judge was right. And our system says if you don't agree that the judge was right, you appeal. And Mr. Speaker, we appeal. The appeal was heard earlier this year, and we continue to await the decision of the Court of Appeal. Now, there are some who would feel that because the matter is still sub judice, because the appeal because we're awaiting the delivery of the decision, that we should not act, that we should do the Court of Appeal the courtesy of awaiting their decision before we decide what to do. Unfortunately, Mr. Speaker, governance does not allow us to freeze like the proverbial deer. Well, we don't have deer. And I've never seen a rabbit. Like the proverbial sheep in the headlight. We don't have the luxury of freezing and saying, let us wait until the Court of Appeal gives its decision. Governing requires that you take positive steps to address the grievous challenges in your society. And while in many instances we may say, well, let's wait until the court gives its decision. We may be right, we may be wrong, we deal with it then. In this instance, Mr. Speaker, the public of Barbados continues to be concerned about the fact that individuals charged with very serious offenses appear to be getting bail with some ease. And if not with ease, with some degree of repetition. Now let me say, Mr. Speaker, that this bill is intended to tighten, to restrict, to constrict the way in which bail is given. And especially so in relation to murders and firearms. But that cannot be seen, Mr. Speaker, as any panacea for what ails us. Amending the bail legislation or bringing a new bail act as we are doing must never be seen as a solution for the problem that we have in this country with the pervasiveness of criminal activity. It would not surprise the members of this chamber, and it should not surprise the country, that in 2018, when we came to government, among other things, on a platform of law and order, we took a series of very important measures in order to be able to address the problem. And if I harken back to what I began my speech with by saying that on matters of law and order, matters of crime prevention, we need to find a mechanism to reach across the aisle and work collaboratively with the other side. We didn't just say it, Mr. Speaker, we did it. In the throes of what was happening in Barbados in 2018, we, for the first time that I know of, gave the opposition of Barbados a national security briefing. We felt that the leader of the opposition, a gentleman that he was, and no doubt still is, was entitled to know what we knew about what was happening in our country. About the guns. When we came to government, Mr. Speaker, we discovered that there were no working scanners at the port. Well, how are you going to intercept shipments of guns coming in if you have no working scanners at the port? We felt that these were things that we needed to brief the opposition on. But not only did we brief the opposition, we brought all of the senators into our national security briefing, and we briefed them too, opposition, independent, and our senators. And then we doubled down and brought in all of the senior public servants. And we gave them the exact same national security briefing. Because it was not just to be seen, the problem of dealing with crime was not just to be seen as a matter for the government benches. It was a matter for all of government. We not only did the briefings, we took a number of steps. We got the former commissioners, we spoke to all the former commissioners of police and said to them, look, you have a wealth of experience. And we want to bring you all together, not to suggest that the commissioner of the time was not up to the task, but to say to the country, we are not sparing any available resource. We're bringing everybody together to help us to solve the crime issues. Two of those former commissioners were indisposed, and therefore we didn't have all of the people that we wanted. But the point is, as an administration, we did not say that we have any political pride in this issue. We wanted to make sure that everybody in Barbados was in a position to put their shoulder to the wheel. But you may say that those are philosophical things. And you might ask rightly, what are the steps that we took? Because a briefing in itself does not help to solve the issue. Mr. Speaker, when we came to government, there were only 2 High Court judges doing criminal matters. Now, what's that to do with bail? Quite simple, sir. Because of the fact that you only had 2 High Court judges doing criminal matters in the assizes, and you would recall that those 2 criminal judges were not permanent criminal judges, they would rotate in and out. So for a period of about 6 months, you have 1 criminal judge doing criminal matters, and then 6 months later, they go on doing family or they go on doing civil or something else. So you didn't have a steady set of hands on the criminal bench. But with only 2 judges doing indictable matters, it meant, Mr. Speaker, that the large volume of matters that constituted the backlog were not making their way through the system with any dispatch. And that meant that people, accused persons, were remaining in Dodge without bail for prolonged periods of time, in some instances 6 and 7 and 10 years before the matter could be heard. Now, accused or not, guilty or not, the system had an obligation to make sure that a person was not deprived of his freedom for any longer than necessary. Because there's always a risk that a person might be found innocent. So what do you do with a man or woman who is on remand for 6 or 7 or 8 years, and then they're found innocent? You can't give back that person the time. You can't give them back the life, the family. So it was incumbent on us as an administration to make sure that cases moved through the system far more quickly so that judges were not constantly being pressed to grant people bail. And Mr. Speaker, as you well know, since 2001, when the 1996 Bail Act came into force, every defendant was entitled to bail. Well, perhaps, sir, that is a facile way of saying it, because the right to bail is actually enshrined in the Constitution. But certainly in the Bail Act, it said every defendant shall have the right to bail. And so murder accused who in previous years never got bail started to get bail. And it was a function of the inefficiency in the court system. You had a lot of backlog and you gave people bail. In order to deal with the backlog, Mr. Speaker, we moved in 2019, a year after winning the election, to appoint 3 additional criminal court judges. So we moved from 2 when we came to government, and within a year, sir, the size of the criminal court bench had increased to 5. And immediately we began to see things moving through the system far more quickly. But in 2022, we recognized that we still weren't where we needed to be. And we added a further 3 criminal judges. So we moved from 2 to 5 to 8, Mr. Speaker. The mathematicians can work out the percentages. Is that 400? Whatever it is. From 2 to 8. And despite the fact, Mr. Speaker, that we had the intervening years of COVID, we saw changes beginning to happen in the way in which cases move through the system. Mr. Speaker, we don't always trumpet our story. But I believe it is important to tell the country, to tell you, sir, and this chamber, that in the 18 months from January 2023 to the end of June 2024, in that 18-month period, sir, our criminal courts have been able to dispose of 584 indictable matters. 584, sir. 584 indictable matters in 18 months. Of that 584, sir, 67 were murders. Mr. Speaker, we've not been talking about these things, but those are the facts, and the facts speak for themselves, sir. In 18 months, our courts have disposed of 67 murder cases. I'm not telling you that 67 people got convicted. A few matters ended up with a hung jury, I think about 3 of them. But the point is, sir, that we took 67 murder cases, and the system dealt with them. A total of 584 matters on indictment in 18 months, sir. That is what a system can do when you give it the resources that are required. Now, Mr. Speaker, you don't see anybody on these benches in court. Well, leader of the opposition. You don't see anybody on the government benches in court telling anybody what to do, how to do it. Daily I get complaints that people didn't get or the fine wasn't high enough. Why so-and-so only get charged with that? How come this body ain't get convicted? Why this body ain't get sent up? Our constant refrain is independence of the judiciary, something that the leader of the opposition would be very close to. Independence of the judiciary, sir. Our job as an administration was to provide them with the resources that they needed. We increased the number of judges from 2 to 8. We increased the prosecutorial staff. We increased the number of prosecutors. Because the same number of prosecutors that can handle 2 judges can't handle 8. So we had to do that too. Whole set of things we did. And without doing any more, this is the result that has been delivered to the people of Barbados. We were in opposition saying, we want to help with the criminal situation. The last administration ignored us because we had nothing to say. We had a bunch of idiots in the opposition, a bunch of low-moves, nothing to say, nothing to contribute. That was their stance. And when we said we need more judges, formerly the opposition said, oh, well, we are going to appoint more judges. But when you check the estimates, they had no money in the estimates to appoint other judges. So it was obvious that that was just fluff. Those were mere promises made to fob off people and to try to put the opposition in its place. Absolutely nothing was done to improve the administration of justice. Absolutely nothing was done to bring about criminal justice reform. And that is what we need, sir. Criminal justice reform. And we began the process by giving our court system the tools that it needed in order to get trials through quickly. And as you immediately recognize, sir, as long as you get trials moved through quickly, the pressure on the judiciary, the pressure on the system to release people on bail becomes less. We would like to see as a benchmark that everybody charged with a homicide should have their trial done within 9 months. We would like to see that. We have no role in the verdict. A jury is who decides if a person is innocent or guilty. But we have an interest in making sure that matters go through the system quickly, because when they do not go through the system quickly, the pressure on the judiciary, the pressure on the system to grant bail is increased. I mentioned criminal justice reform. We wish that we could wave a magic wand and deal with all of the issues related to criminal justice reform in one fell swoop. That could not be. But I'm happy to tell the country that last year my office hosted a symposium on criminal justice reform. Coming out of that symposium, Mr. Speaker, and I should say that that symposium was a huge success. We had a large number of attorneys, especially members of the criminal bar. We had people from the prison system, people from the probation system. We had civil society, people from the church. We had the judiciary. We brought everybody who had an interest. Probation, everybody, police, everybody who had an interest in the criminal justice system. We brought them together for 2 days of discussions. And arising out of that, a number of decisions were reached by consensus. One of those decisions is on the paper today. We'll do that debate later tonight, the plea bargain legislation. But another one we passed just a few weeks ago, judge-alone trials. We are talking about reforming our criminal justice system in meaningful ways so that the victims can receive justice in quick order, and so that justice can be dispensed to the accused also in quick order. Both things have to go together. So in addition to increasing the numbers of people in the judiciary and the numbers of prosecutors, we've gone further and we've said, let's add an alternative, because there are people who may prefer to have a trial by judge alone rather than going to a jury. So we've added that as an available measure intended to help to ease the backlog. The plea bargain legislation that is on the paper, on the order paper, and I know that we're not, I don't think the rules allow us to speak about things that are to come, but that is there. Another measure that is intended to ease the backlog. We gave the DPP special staff for the purpose of, as the jargon they use is nolli prosequi, going through the old cases and trying to make a determination as whether justice could be served by prosecuting a case today that is 20 years old. Witnesses' memories have faded, witnesses have died, victims are no longer interested. That is the way of humanity and life. And we felt that that was a good solution towards getting some of those cases out of the system, so we gave the DPP staff, and that has also been working. We also are putting in place new criminal procedure rules, which when they are completed, they're out to the bar and the other stakeholders now for consultation. The plan, Mr. Speaker, is to get rid of committal proceedings altogether. You would know that years ago you used to have something called a preliminary inquiry. And under our administration, we got rid of that and switched to paper committal. But after now 15 years of paper committals, we've now asked ourselves, is this still a necessary element of our criminal justice system? And the view is that it no longer is a necessary element, and we therefore propose to get rid of paper committals so that matters will again move through the system far more swiftly. This administration has taken the issue of criminal justice reform seriously and are putting the legislative things on our books. Mr. Speaker, I was in Guyana only 2 or 3 weeks ago, and sat in the audience as the DPP, Director of Public Prosecutions of Jamaica, spoke glowingly about the response in Jamaica to their plea bargain legislation. The Chief Justice of Belize spoke glowingly about their success with plea bargain legislation. All across the region, they talked about how it helps you to avoid unnecessary trials, take them off of the docket, move things through quickly. And if we can get all these things together and we're putting them in place, this 584 that we saw in 18 months could be double, sir. Could be double. And we are working assiduously to all that. And again, sir, I need to tie it back into bail, because the issue of bail becomes a burning issue when after an extended period of time on remand, your case has still not started. And the lawyers go to the court and they say, my client has been on remand for 2 years or 3 years. His case has not started. We don't know when it can start. It is unjust to keep his or her client in prison. And so we want bail. So we can't tell the courts if to grant bail or not. We can't. What we have to do is to ensure that we reform the criminal justice system in such a way matters move quickly and the pressure on the system by bail is eased up. Mr. Speaker, while today's discussion is about bail, a part of criminal justice reform, I feel it is important that I should also say to the country, we have put in place other measures to try to keep our young men and women from following the criminal route. But, Mr. Speaker, we have to be honest with ourselves. People call the police after the act or the criminal act has happened. Very few of them will ever call the police before and say, I went in my son's bedroom and I see a gun. None call the police and say so. None call the police and say, in my house under a flooring board is some drugs. They're not going to say that they see suspicious activity happening in the backyard and that they feel that somebody hiding things in there. They never call the police for that. They always call the police after it has happened. And then they say, what the government doing? What the government doing? You know, the last Attorney General, I doubt that there were 3 things he ever said that I agree with. I doubt. But one thing I took note of that he said at a public venue, and for once, I found a reason to agree with him. He said, government in who raise them children, parents have to be responsible, have to bear responsibility for what their children have become. But everybody wants to say, the government this, the government that, the AG, what the Minister of Education doing, what the Minister of Youth doing, what the Minister of everybody doing, without understanding that in the eyes of a child, a parent is the first and most important minister, more important than the minister in the church. In the eyes of a child, the parent is the most important minister. But yet still all across the society, notwithstanding that we are doing all of the things that we're doing, notwithstanding that the budget of the Barbados Police Service is higher now than at any time in our history, and not because of any sense of panic, but because we recognize that we have to equip a modern police force with the tools that are necessary. And tools are not just cars and equipment. Tools are also training, self-improvement, all of those things. Higher. It was higher than ever it was last year, and we increase it yet again. But yet still people find it easy to run and ask, what the government doing? The Minister of Education has some notional charge of those children between the hours of 8:30 in the morning and 3:30 or 3 o'clock in the afternoon. Call that 1/3 of the day. Who has responsibility for them, Mr. Speaker, for the other 2/3 of the day? And many of them, Mr. Speaker, I heard of an instance recently where the police were called in to a school, a secondary school, to deal with a student who brought to school a knife on the last day of school. And there was a suspicion that this knife was not meant to cut cane. And the police were called in. And they spoke to the parent and said, based on the child's reaction and so on, we may have to send this youngster up to the industrial school. You know what the parent is reported to have said? It wasn't there. The parent was reported to have told the police, carry along, there's one less mouth to feed. Carry along, there's one less mouth to feed. Now, when that boy finds friendship on the block, why would you be surprised? When that boy finds role models and parental figures and all those kind of things that he's looking for at home, out on the tamarind tree, why would you be surprised? That is the society that we live with. So, Mr. Speaker, for anybody in Barbados who believes that coming to Parliament and bringing a new Bail Act, coming to Parliament and bringing plea bargain legislation, coming to Parliament and bringing judge-alone trials, increasing the budgets of the court, those are all the things that we do as a state, as a government. But if people believe that they can abdicate their own personal responsibility for what happens with their children and what happens in their society, I say that they are wrong. They are wrong, Mr. Speaker. On this ship of state, everybody has to hold some weight. Everybody has to hold some weight. We are responsible for making sure that the educational system works, yes. We're responsible for making sure that our services sector works, yes. We put the financing and the expertise on the table to capture those people who might be falling through the cracks. And we recognize, Mr. Speaker, that there are some people who, for them, the most important thing is the job. And we've put programs in place. Put programs in place to ensure that our young men and women have a reason to get up and go to work. Perhaps that is the biggest discipline that our young people need. They need to know what it is to get up and go to work and have to work. We put all these things in place, Mr. Speaker. But unless those parts of the society, the parents and so on, recognize that we are only part of our solution and that they make up the other the other 2/3 of the day, then our resources will have gone to nothing. I'm going to get to the Bail Act very shortly and go through the provisions for the benefit of the country and the chamber. But I just want to make a few other general points. As at the end of January, Mr. Speaker, we had 106 murder cases awaiting trial. 106. We had 8 manslaughter cases, and we had 254 firearm cases. Let me just repeat those stats. At the end of January this year, 106 murder cases awaiting trial, 8 manslaughter, 254 firearms. Now I'm waiting on the specific statistics, but I've told you that by the end of June, we had gotten rid of 67 murder cases, so I'm trying to figure out how many of those 67 came in between January and the end of June. Those are the figures we're dealing with. I asked the DPP 2 weeks ago to give me the full number of matters awaiting indictment. The response that they gave to me was 1,600. 1,600 matters awaiting indictment. And every day we're adding, sir. So this is the gift that keeps on giving. Every day we're adding. More people are charged. We've looked at the statistics and we can see that about 50% of the individuals in DODs are on remand. So 50% of the prison population are people who are convicted and serving time. The other 50% are on remand. But the Minister of Home Affairs will be able to tell you that the number of people in prison has actually dropped. So we have fewer people there than before, of both categories. Fewer people convicted and fewer people on remand. I think, but he can clarify the nature of those statistics. We still have a way to go. We still have a way to go. We've made commitments to our police service, and those commitments are being kept. I want to thank the members of the Barbados Police Service yet again, for their unseen hard work. People don't seem to appreciate what they do. But in addition to the police service, there are some other sensitive agencies who also have to carry a lot of weight, or immigration, or customs. These are all entities that work in lockstep with the police service to help to secure our borders, whether by air or by sea. We also have the input of CARICOM agencies and like CARICOM Impacts, the implementation agency for crime and security. They're responsible for a lot of training, a lot of resource mobilization. We have the regional security services that have played over the years an integral role in making sure that our police officers are trained. So in addition to the things that we do, there are a lot of other players who help to keep Barbados safe. Now, Mr. Speaker, there is no doubt that we've had in the first part of this year a significant uptick in the number of homicides. The total number of homicides for last year, I believe, was 21. And so far for the year, the official number is 26. So between January and now, we've had 26 homicides, while in the whole of last year, we only had 21. In 2019, I think we were up at our highest, 48. And we've gradually been getting it down to last year's success. So far this year, we've had an uptick. Let me tell you a little something about those numbers, though, Mr. Speaker. Of that 26, 17 were firearms. So 17 of the 26 were firearms. The remaining homicides, 6 were stabbings, and the other 2 homicides were bludgeonings. In one case, a hammer, in another case, somebody who was struck on the head with a piece of wood. So we've had a total of 26, 17 were firearms. Now, Mr. Speaker, I want to assure the country that that number, we feel about that number a tremendous burden. because we understand what it takes, what it will require for Barbados to be firing on all of its cylinders. If people feel unsafe in their homes, unsafe in their communities, then economic activity is going to dry up. Economic activity dries up, then the capacity of people to earn dries up, and then we have perhaps a vicious circle, and we go on, perhaps spiraling deeper and deeper. The numbers are a concern. But we don't look at the numbers and panic, Mr. Speaker. We redouble our efforts. We have put things in place. And in every instance, when we've redoubled our efforts, Mr. Speaker, we have seen success. The level of firearm seizures is at an all-time high. We are going out there and intercepting vehicles and getting firearms, and not just old guns. We're getting AK-47s, those kind of things. Those are things that are being seized by the police service. Glocks. Those are things that are being seized by the police service that are in the hands of the criminal element. So even though we have put scanners in place, we continue to train our customs officers, we continue to train our police, we use other techniques to make sure that we are able to seize as many firearms as possible. So, Mr. Speaker, what I'm trying to paint for you, the chamber, and the country is a government that has not just been talking the talk, a government that has been making state investments to deliver criminal justice reform to the people of Barbados. And whatever they may say, these numbers mean something. 584 matters disposed of. Tell me how long it would take 2 judges to dispose of 584 matters. So the leader of the opposition speaks on behalf of a discredited group of people. He speaks on behalf of a set of individuals who couldn't address any of the issues, but find it convenient now to sit and throw pot shots, pelt pot shots, fire pot shots at an administration that is doing rather than an administration that is saying. Mr. Speaker, the granting of bail for murder accused started when the last administration was in government, I believe. So much so that the Prime Minister then and the Attorney General then said, we didn't even know this was happening. We did not know. The Prime Minister then said to the public, he did not know that murder accused were getting bail. He couldn't understand why. Because the problem was happening back then, sir. And what was the problem? We came to government and found that individuals charged with 1 and 2 murders were being given bail. We came and found it so. People charged with multiple murders were being given bail. People charged with a berriffle of firearm offenses were being given bail. We came and found it, Mr. Speaker. Our mission was to arrest it. And that continues to be our mission. So what have we brought to the chamber today? Mr. Speaker, we have looked at legislation in other parts of the world to see who, in a situation like ours, has addressed the issue. Now, different countries have different challenges, but I can say to this country that we looked at several nations, but homed in on the legal position in South Africa. And we looked to see how South Africa address the issue of bail. You see, Mr. Speaker, we didn't think it was necessary to try and reinvent the wheel. South Africa has constitutional provisions similar to ours. In many respects, they are dissimilar too. They're not similar across the board, but they have positions that are similar to us, concepts that are similar to us by virtue of being in the Commonwealth, and follow similar constitutional approaches and theories. In fact, Mr. Speaker, over the last 20 years, there are many decisions of the South African Constitutional Court that have been relied upon not just by Barbadian courts, but also by courts across the region. When we had some of the cases that challenged the constitutionality of our COVID restrictions, we looked to South Africa, and our courts were able to follow the jurisprudence that came out of the South African Constitutional Court. On matters in relation to cannabis, a similar thing happened. So our judges are not unfamiliar with the reasoning and the thinking and the jurisprudence coming out of South Africa. And South Africa had a situation, Mr. Speaker, far, far worse than ours, but they had to deal with the issue of bail as well. They had to deal with the issue of bail. And we were attracted to the approach taken by South Africa, Mr. Speaker. They did not say, as we did in 2019, you can't get bail for 24 months if you are charged with X firearm or murder. They didn't take that approach. What they did was to incrementally tighten or set out criteria which must be met before an individual could get bail. And they too have a system which separates murder and firearms, and how you deal with bail in murder and firearms from how you deal with bail in other matters. We were attracted to the way in which the South African Parliament addressed the issue of bail, and in their system, notwithstanding that their constitution, like ours, says you are entitled to get bail whether conditionally or unconditionally, both our constitutions say that, they, by virtue of their Criminal Procedure Act, said you can get bail in the interest, if it is in the interest of justice to do so. Now, that might not seem like a stretch because every judge acts in the interest of justice. But this particular statute, the statute in South Africa, went into a whole set of criteria which sought to establish when it would be in the interest of justice to do so. So in South Africa then, you can get bail if it is in the interest of justice to do so. And in order to determine what is in the interest of justice, the South African Parliament then set out a wide range of criteria and a wide range of factors to be considered when trying to determine if a particular criteria fits. Now, Mr. Speaker, it is possible that what we are doing today may receive a constitutional challenge just like the one in 2019. That is what the courts are for. This Attorney General is not afraid of a constitutional challenge. Every speech that has been given by the Honourable Leader of the Opposition, except for when he spoke about the sheep, every other speech given by him in relation to any law that has come to this chamber it is unconstitutional. It is unconstitutional. Somebody probably got there to tell him that the tired hearing he say so, and last week he switched it and said, in my opinion, it is unconstitutional, but it is my opinion. He has evolved his reasoning. I have no doubt, Mr. Speaker, that today I will hear him say at least a dozen times in the first 5 minutes that it's unconstitutional. It is unconstitutional. It is unconstitutional. The difference between him and this administration, Mr. Speaker, is that we are not afraid to have what we do tested in the court. What we are afraid of, we are afraid, sir, of being like him, a sheep frozen in the headlights. We are afraid, Mr. Speaker, of doing nothing because it might be inconvenient to do it. We are afraid, Mr. Speaker, of not responding to the needs of our society just because there are some people who might want to tie up time on White Park Road in the courts and argue that it's unconstitutional. Mr. Speaker, if there is one AG, I have probably had more constitutional challenges than any other. We had dozens of challenges about COVID, we went on. We had challenges about the election, we win those too. Challenge after challenge after challenge, Mr. Speaker, whatever constitutional theorists may say, they are entitled to have their day in court. But as a Parliament of Barbados, we must act. And so to look at the specific provisions, Mr. Speaker, I want to jump straight to the provisions in relation to people who are charged with firearms, because that's really the nub of what we're talking about in here today. And I'm happy to engage the honourable member on constitutional theory. I'll even lend him a few books. This bill, Clause 610, and Clause 610 relates to murder and firearm offenses, because in that regard, Barbados and South Africa are on the same hymn sheet. Murder and firearm offenses are the most disruptive offensive to our society. They are the cancer of our society, and we have to treat them differently, plain and simple. And I believe that the leader of the opposition would agree, because he said that we need to amend the Bail Act to provide that murderers, people charged with murder can't get bail. So we must be beginning from the same perspective, that those are the most hideous of offenses and have to be dealt with differently. So the provision that we seek to pass in this chamber today says that where a defendant is charged with either murder or firearm offense, the court shall order that the defendant be detained in custody until the defendant is dealt with in accordance with law. That's the first thing. This is where it begins. This is the floor. This is the foundation material that we have here. The court shall order that the defendant be detained in custody until the defendant is dealt with in accordance with law. That's the floor. But it goes on. Unless the defendant, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which, in the interest of justice, permit the defendant's release. It may sound a bit long, Mr. Speaker, but this is easily broken down into its component parts. So the floor, the basic position is that the court should say, if you charge with murder or firearm offense, you ain't going nowhere. That's the basic position. You ain't going nowhere. But it goes on quite clearly and says, unless, so it goes from you ain't going nowhere to you ain't going nowhere unless. So you're not getting bail unless you adduce evidence which satisfies the court that exceptional circumstances exist, which in the interest of justice permit your release. So you must produce evidence. So you can't just come to court and say that my client has a job, my client is a father of 4 children, my client is a hardworking man, my client has not had any other convictions, this is my client's first charge. coming to court and making those bold statements are now a thing of the past, or they will become a thing of the past. Because what the lawyer gets up and says when he is addressing the judge is not evidence. What the lawyer gets up and says when he's addressing the magistrate is not evidence. The lawyer can't give evidence. The existing Bail Act does not address any of these issues. Does not address any of these issues. And so we've adopted a cavalier sort of approach. It may have become a little bit more sophisticated of late. It has been a long time since I have set foot in a criminal court. But for the first time, we are now seeing a statutory requirement that says you must bring evidence. Evidence of what, sir? Evidence that satisfies the court that exceptional circumstances exist. Now, Mr. Speaker, when I tell you that we are fortified in our position that the South African approach is a viable one, it is because all of these elements have been addressed by the Constitutional Court of South Africa, sir, not their regular court, by their Constitutional Court. And that Constitutional Court has looked at the issue of what exceptional circumstances mean. And it says that those are circumstances that must weigh exceptionally heavy in favor of the accused person. It says that it means circumstances that are unusual, out of the ordinary, and of particular importance. So the statute is saying you must bring evidence to satisfy the court that there are circumstances that weigh exceptionally heavily in your favor that you be granted bail. Didn't exist before, but it is here now. It will be here now. And that evidence of exceptional circumstances must then be looked at in the context of the interests of justice, because it goes on to say that these circumstances must exist which, in the interest of justice, permit the defendant's release. What we have here then is a requirement that is very, very different to what currently exists in the law. And you can look at the provisions of the Bail Act to see, and remember we amended them in 2019. So what you need to look at is the 2019 amendment. But you look at those in addition to what was there what was in the original act, and you try to see, well, what are the circumstances in which a court would refuse bail? And you see what they are. But they are of a completely lower order of magnitude to what we're insisting on here. And yes, Mr. Speaker, there may be some trepidation, there may be some reluctance about approaching the matter of a constitutional right to bail in this way by appearing to be making it harder for an accused person to get bail. But what we're doing, Mr. Speaker, is acting in the best interest of a society, because it is standard. It is standard constitutional theory that rights given to you in the Constitution have to give way to the interests or to the greater good of the society. The Constitution says so. That a person has the right to X, Y, and Z and can enjoy those rights, but your enjoyment of those rights is subject always to what is for the benefit or for the greater good of the community. That is the balancing act that has to happen. You have the right to do this, you have the right to do that, you have the right to have this benefit, but where the exercise and the enjoyment of your right clashes in a way that cannot be accommodated with the rights of the majority, then, Mr. Speaker, your right has to stand subjugated. And that is what this is about. So throughout these amendments, throughout this new act, sir, we now are talking about what is in the interest of justice? So let me tell you a little bit about the interest of justice. For the first time, Mr. Speaker, a court, for the first time, a court has to look at specific issues relating to the grant of bail, and the Act goes into great detail. So let me tell you about Section 6, Clause 6.7. Clause 6.7 says, in addressing the rights found in Clause 2, in addressing the grounds in Clause 2, let me tell you what it says. Clause 2.6.2e says that one of the grounds is where, in exceptional circumstances, there's the likelihood that the release of the defendant will not be in the interest of public order or public safety or public security. So we're going into a level of detail that we never did before. So where there's a likelihood that releasing the defendant will not be in the interest of public order or public safety or public security, then you cannot get bail. So the court then, in Clause 6.7, tells you what the bill in Clause 6.7 then tells you what the court would look at. So in the area of public order, public safety, and public security, this is what the court will take into account. These are the things the court will take into account. And I invite the country's close attention to these. It says, whether the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community. Where the nature or circumstances of the offense that the person has been charged with is likely to induce a sense of shock or outrage in the community, bail is not in your favor. And Mr. Speaker, we have so many of these instances. You remember the shooting death in Sheraton Center in broad daylight, on the very day that you had a tour from the blind, from the disabled community, people who can't see what's happening, who got to scramble for themselves. And a man goes into Sheraton Mall in broad daylight in a food court and shoots a man dead. Campus Train's murder. You throw a Molotov cocktail in a one-door place and burn alive 6 women. These are the kinds of things that will induce a sense of shock or outrage in our community, and rightly so, sir. This bill is saying, bail is not in your favor. The other ground is whether the shock or outrage of the community might lead to public disorder if the defendant is released. Now, Barbados is not the kind of society that generally does protest marches and things of that sort. As we speak in Venezuela, there's a whole set of outrage about the outcome of the elections and things of that sort. We're not that kind of society, but the court has to consider whether the shock or outrage in the community might lead to public disorder if the defendant is released. C, the court must also consider whether the safety of the defendant might be jeopardized by the defendant's release. That is a factor as well. If you're released, what will happen? There are individuals who are on bail who get shot down and killed. We had an instance where a person was on bail for murder only about 3 or 4 Saturday nights ago. A vehicle pulled up, shot him dead. D, whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the defendant. So what is the reaction of the society here? Is the society going to feel comfortable? Is it going to be able to maintain a sense of peace and security? Or will it be undermined if the defendant is released? And the next one is key. Whether the release of the defendant will undermine or jeopardize the public confidence in the criminal justice system. will it undermine the public confidence in the criminal justice system? These are some of the factors to be taken into account. And Mr. Speaker, I'm not going to go through all of them, but this just deals with 2E, 6.2E. There are a whole set of other factors that need to be taken into account in every area. Now, Mr. Speaker, you would rightly ask whether putting this burden on an accused is not, in essence, putting an undue burden on him in the context of a presumption of innocence. And I understand why the criminal law and constitutional theorists would raise this kind of concern. But again, the jurisprudence out of South Africa says your right to a fair trial and the presumption of innocence is something that arises at a trial. Those issues arise at a trial, not at a bail application. And the South African constitutional courts have said so clearly. A bail application and a criminal trial are two completely different things. And while both have to be dealt with in a judicial way, the question of an undue burden being placed on an individual will not arise because those are rights that are dealt with at a trial. On a matter of a bail application, those issues have to be viewed as operating at a far, far lower threshold. Now, I have no doubt, Mr. Speaker, that there are those who will be wondering, but why are you saying that you are making it harder for a person to get bail even though that person is innocent? Well, Mr. Speaker, we have to accept that in our system of justice, a person is in fact innocent until proven guilty. The Constitution does say you have a right to bail, you have a right to be released until trial, either conditionally or unconditionally. But it is also a part of our system which says that in certain circumstances we are not going to release you, and therefore, as a parliament, we are weighing in on the issue, and we are saying that judges now have to approach it from a completely different angle. Now, the role of the judges in this system, Mr. Speaker, we are not taking away any discretion from the judges. But a judge will find that on a bail application, he or she now has to consider a greater raft of criteria in greater detail. And he will only consider them when evidence comes before him or her. If the accused doesn't bring any evidence, then the accused is not discharged the burden, and bail is not an option. The accused now has to go to a court and say, I want bail because I am entitled to bail because, and I want you to exercise your discretion in my favor. Mr. Speaker, there are other provisions. I've spoken for a bit long, but there are other provisions I want to mention briefly. For example, the importance of giving reasons. Now, the need to give reasons has always been a part of our Bail Act. But the fact is, because there was little criteria settled in the statute, the burden of giving reasons was not so great. And in addition to that, there was no right of appeal from the prosecution. So the defendant get bail, we want reasons for. And if he didn't get bail, even though there was a provision here that said it just said you had to record the decision and the reasons. We are stepping this up though, Mr. Speaker, because for the first time the law will say that the prosecution has the right of appeal. So where a court grants bail, for the first time, the prosecution has the right to appeal the decision to give bail. And in those circumstances, Mr. Speaker, in those circumstances, the reasons for the granting of bail become critical, because the prosecution must be able to say the judge misdirected himself. There was not any evidence of X, Y, or Z. So by putting a provision in place which allows the prosecution to appeal, the system in relation to bail is much fairer, and the prosecution can now weigh in effectively on bail matters. Mr. Speaker, I will also say that we've had a number of salutary provisions in our Bail Act that work for us, and to that extent, we've kept those provisions in place. So members of the bar who deal with bail applications will find that a lot of the technical issues and so on relating to sureties and so on, things of that sort are still in the Act. So those are still very much part of the new Bail Act. But the superabundance of obligations in relation to the accused and on the bench and so on are to be found, Mr. Speaker, in the earlier provisions, Section 6 and others. Mr. Speaker, I believe I have detained the chamber for too long. I will have the opportunity to wrap up. So if there are any other things, I will come back. But suffice it to say that this step is one that we believe should not drag out and be kept in the parliamentary process for overly long. It is urgent, Mr. Speaker, because the situation that we face is urgent. Individuals are getting bail every day in circumstances where right-thinking members of our society, if there were judges, they would not want to give bail. We also have a public that is rightfully asking, why are courts giving bail so easily to the criminal element? What it does is emboldens them. They feel that they can get bail easy, so they can come out and do what they want to do. And the society becomes the real victim. This matter is urgent because the government recognizes we can't wait until the Court of Appeal delivers its decision. Nor can we wait when we have a good idea that this approach is one that will assist us in maintaining law and order in Barbados. Mr. Speaker, the opposition senators have complained that they have not had enough time, and on and on and on and on. In a society where there's unrest, time runs against all of us. And therefore, I make no apology for coming into this chamber and asking that we do this bill in all its stages. We are at a critical juncture. Crop over is here. I can't disclose any of the police intelligence, but I can tell you, Mr. Speaker, that on a daily basis, the police are responding to this and to that and the other. These things are not going away. And the firm hand from the state will send the right signal to the criminal element that we will not be tolerating this kind of behavior at all. I beg to move that this bill be read a second time.
Honourable members, brace yourself.
Thank you, Mr. Speaker, and good morning to my parliamentary colleagues and to the rest of Barbados that may be listening to this debate. I may, if I were so self-consumed, flatter myself into believing that the Honourable Attorney General brought this legislation only due to my recent agitations. But at the end of his speech, he does say that it has come here because of social unrest, and that in those circumstances, it becomes urgent. So that This is one of those rare occasions on which the learned Attorney General is now admitting to this country that he rules in a dispensation in which there is social unrest. And that is an interesting...
Mr. Speaker, I raise on a point of order. The Honourable Leader of the Opposition is misleading the House. Sir, I thought that he might have just been warming up, and maybe it was a slip of the tongue when he said that the Honourable Attorney General admitted that there was social unrest in Barbados. I was prepared to let that slide. But when it became obvious from his second repetition, sir, that this is a pattern that he's probably going to employ for the rest of his speech, it's necessary for us to correct the record. The Honourable Attorney General at no point said anything or admitted anything saying that there was social unrest in Barbados. He said, sir, in the interest of the public, it was time to do this. Sir, this is a very, very serious bill. This is one that we need the public to understand and buy in. This is one that the opposition leader had called for as well. So let us keep it clean, sir, and just deal with what is in front of us.
Honourable Member, I am sitting in an impartial seat, and I have noted your point of order.
I'm obliged to you, Mr. Speaker. I think Barbadians now understand why at the end of every speech that the learned Attorney General makes, the Honourable Member for Christchurch East likes to follow immediately after him, well, after me. Of course, the learned Attorney General did promise this chamber that he would elevate the quality of the debate and that it would become academic and perhaps philosophical, and that our views as to the question of bail would be harmonized. And I wondered when he said that if the learned Attorney General had not been intending by elevating the debate to exclude the Honourable Member for Christchurch East. And if that were the intent of the learned Attorney General, if that were the intent to elevate the debate so as to exclude off his back the Honourable Member for Christchurch East, I join with him, because today we intend to elevate this debate. We intend to be academic by the learned Attorney General's invitation, and we intend to be philosophical and not to grovel in petty domains of pseudo-discourse. So I'm obliged to you, sir, for allowing me to continue and to hope that this is one of those days, one of those occasions when we will not hear these interruptions and when I can face the learned Attorney General and discuss the law such as we know it.
Honourable Member for Christchurch South, when you make mention of interruptions, etc., I am the sole authority on whether there are interruptions or not. So I just want to calm your nerves if they exist. I am the determining factor as it relates to whether there will be interruptions or whether there are interruptions, and if there are interruptions, etc. You can't, Honourable Member, speak to interruptions. I am the sole person and the sole authority on that.
Your Honour.
This is not like last week, Honourable Member. I'm in the chair.
This is not like last week.
I'm in the chair. I am in the chair. So I just want to calm you and also warn you.
Well, last week was good.
I know, because I wasn't here, but I am here.
No, the goodness had nothing to do with
I just thought I would mention that to you.
Yes, but last week was excellent.
Yes, I'm glad to hear that. You can continue, Honourable Member.
And this week will be excellent.
Of course, because I am here.
I'm obliged to you, sir. I'm obliged to you, sir. So that not only was the learned Attorney General attempting or intending to exclude the Honourable Member for Christchurch East, but the public is now also aware that there is a distance between the learned Attorney General and the Honourable Member for the City, who I understand occupies some space close to the learned Attorney General, to the latter's discomfort, so that if it is his purpose, his official purpose, to distance himself from both gentlemen, I understand his plight, and I would I empathize, in fact, with an Attorney General who finds himself burdened by these unwanted presences, both in debate and in his physical office. Nobody knows where that member for the city, honourable member for the city, is today, but the learned Attorney General has my sympathy. I empathize with him for the general plight that he experiences in the conduct of his official duties. And he can be assured from me that I will discuss this matter today with some academic intensity and proceed to make our own recommendations. He did say that we recommended this urgent intervention. As I said earlier, I'm not flattered by that. It is the circumstances in which Barbados presently exists. I believe since April, we may have had in this country some 20 homicides. And if that is the case, if those statistics bear any relationship to truth, one can understand why the Attorney General feels this need to come here today to make it more difficult for these miscreants. And of course, when I say miscreants, I mean the people who committed allegedly committed those offenses. So I'm not going to flatter myself. Alleged miscreants. Alleged miscreants. But you have my sympathy. Now, this question of bail, and we're being academic here, Your Honor, and in fact, one of the reasons I'm glad you're here today is because this is a matter of law, so that we can now establish a triangle here between the learned Attorney General, myself, and yourself, and back to the learned Attorney General, and to exclude he who shadows or thinks that he is shadowing the learned Attorney General. Let him continue to think that.
Honourable Member, I'm glad it's academic.
Beg
I am glad that it is academic.
It will be academic. This is a serious matter. This is a very serious matter. This is a serious matter in which the police will tell you that there are people running around this country on bail for murder, committing other murders. So that is a very serious state of affairs. It means that if there is social unrest, that unrest is localized to a certain community of miscreants. And the law must find a way to deal with those miscreants. So let us pursue the debate. Now, we all know that bail is rooted in that constitutional right to freedom. The Constitution, liberal as it is, will tell you that everybody has a right to personal freedom. But of course, the lawyers will always tell you that freedom, there must be a positive concept of freedom. Freedom is not the right to do what you want to do. It is the right to do what you ought to do. And they always say that your freedom ends where the rights of others begin. So that freedom is not absolute. But this is the clause of the Constitution, sir, with which you are familiar. And while I'm addressing you, it is our purpose really to educate the public as to why these things are done, why the question of bail is so important. Section 13, subsection 2 of the Constitution, and you read that every day in court, sir, is the section that would be of some importance today. That relates, I beg your pardon, Section 13, subsection 3. And this is where the whole issue becomes rooted. This is where a person is arrested or detained, and it is said that he should be brought to trial as soon, and this is the operative phraseology here, as soon as is reasonably practicable. And that's where the dilemma begins, that a man allegedly commits a murder, the court remands that man, and the Constitution of this country says, as soon as reasonably practicable, I beg your pardon, he must be brought to trial, so that the state has the right, through the operation of the court, to remand that man, because it's a serious offense. And in history has always treated murder accused as being among the worst of the offenders. Of course, the learned Attorney General did make passing reference to treason. We've not had that around here. So that murder has been at the apex of criminal wrongdoing in this country. And we've had a historical tradition in which they did not get bail. And they did not get bail because the offense was considered too serious to allow the man back on the streets. Of course, there were some men who committed murder in circumstances that were really misadventurous. A fight, a mistake, a crime of passion, no intent to really disrupt the entire society. And perhaps in those cases, in past times, if they had been granted bail, they would not have done the murder again. But today it becomes urgent because we have discovered that those committing the offenses have committed a similar offense in recent times. So here's the Constitution saying to them that they're entitled to bail. And here was a ruling from the court saying that you can't keep them for more than 24 months. And here's a situation in which the courts become overrun with several criminal offenses. This is accepted on both sides. We all understand, all 30 parliamentarians in here understand the dilemma that this country faces. That there are several murders being committed, except that the public must be aware that a law exists that you really cannot keep these people up there for more than 24 months. Again, precisely because of another constitutional principle. You know it, sir. Section 18, which speaks of a presumption of innocence. That you could see one man shoot another man at midday in Broad Street. And you take him to court and you send him to prison, and the Constitution presumes that he is innocent. But that's a legal presumption. Doesn't matter what laypersons think. The legal presumption is that he is innocent. Whatever we've seen at midday, whatever we think, he is innocent until a court finds him guilty. And if a man is innocent, which in many cases is a legal fiction, really, if a man is innocent, he has a right not to be detained. So that is the practical dilemma that the Constitution has created. And how do you resolve that constitutional situation? You do what the learned Attorney General has attempted to do today. And I use the word attempted because we are not certain of success. No one is ever certain of success. But I've heard the Attorney General more than once, and he repeated it again today, say that When he came to this administration, there were 2 judges. The courts were inadequately resourced to give expeditious trial, so that injunction from the court that you could not keep a man for more than 24 months made life difficult, not only for governmental administration, but for the judicial administration. How do you discharge people through the system in less than 24 months when there are so many offenses being committed? And equally important, when the court itself is inadequately resourced. I visit the Learned Attorney General with this news today. He boasts that I think he now has 8 judges, 8, I think that's the number, in the criminal courts. That is correct. He understands that, the Learned Attorney General understands that there are more murders being committed. The Learned Attorney General understands that he has a crisis on his hands, and it is a national crisis, really, because nobody rejoices in the unrest that visits the civility of this country. I will visit the Learned Attorney General with some news today he may not know. He accused me of going to court, and he's correct. That is an accurate accusation, so that I know. I know that some of the courts do not work as efficiently as they should do because there's a problem of inadequate staffing. Transcription is an important, and the Learned Attorney General may now take notes. Transcription, when he left the courts those many years ago, they didn't have transcription. The judge used to do his longhand. So if we take him, if you and I take him across there, he will now discover a shortage of transcription clerks throughout the court system. You and I will take him to the ancillary services. We will take him to the Child Care Board, where there may be shortages as well. And as you and I know, the Child Care Board works in tandem with the courts. That would be more or less the family and domestic courts. We will take him to the probation department, which is very active in its participation in the criminal justice system. And we will show him a situation in which there are not enough probation officers. And you and I know, sir, that a court will not pass a sentence in 2024 in a serious matter unless you have a probation report. So we will take him there as well. And that is not all. There's the Child Care Board, there is the probation department, there may be the welfare department, because I believe occasionally you will need a welfare officer to give evidence, occasionally, to give evidence in matters of child support and so on, the domestic courts and the magistrates' courts. We could also take him to a department with which he may be more familiar, but he may be losing his grip on that one, the Barbados Police Service. He will discover that there is a woeful shortage of police officers, and that life is not easy for a police officer if he has to work up to 11, 12, midnight, and then give evidence the following morning at 9, so that the distribution of duties amongst police officers makes life extremely difficult for a police officer. People in this country don't understand how difficult policing is. They don't understand the plight of nurses. They don't understand the plight of teachers in this system. But we come in here and we banter, and we believe that life for other people is as great as it is for, I will be careful and say 28, for 28 members of parliament. I will exclude you, sir.
You're excluding yourself too, sir?
Yes, 28.
So you're not a member of this chamber, I believe.
No, I say that life is great for 28 parliamentarians.
No, we're just checking the English language, sir.
Yes, and I have excluded the two of us.
Do not call me, sir, when you speaking, speak to yourself. I'm not part and parcel of any discourse in relation to any debate in this house, any pronouncements from you, honorable member, with the greatest of respect.
I am not.
So I am not gracious in relation to those remarks at all.
As you please, Mr. Speaker, as you please. So that if you join the luxurious life that is that of the government members of the parliament, I applaud you. But mine is not a luxurious life, as you know. And that is because you and I work so hard. Here, in the courts, and elsewhere.
Honorable, I thought you were speaking to the bill. Sir.
I am,
So
sir. I am. And I was speaking about the difficult life that confronts the police service in this country. So that you and I were taking the learned Attorney General on a tour through the criminal justice system and indicating to him that with his best intentions of bringing a bail act to this chamber, that does not solve the problem that confronts the criminal justice system. But he has tried to meet his mandate to pass a law. Now, I will make some comment on what he has attempted to do here today. He has told this chamber and this country that he has, I don't think he will, the learned Attorney General will object to me saying this, that he has more or less lifted in his urgent dispensation, that he has lifted this law from South Africa. Barbadians justifiably become very sensitive on the issue of South Africa, and he will want to assure Barbadians that this legislation that he brings to this country did not find its birth in apartheid South Africa, that he will want to assure Barbadians that this law, this South African law, I don't mind calling it that, further to what the learned Attorney General has admitted, he will want to assure this country that this law is recent South African law, that this law found expression or found life post, I would say, 1990, when Mandela was released, let us say for safety, absolute safety, post 2000. Because a constitution and an act of parliament are not exclusively legal documents. A constitution and an act of parliament are political documents. They're social documents. And they're cultural documents. The law does not exist independently of its social reality. We all know that, but often we need to remind ourselves of that. And that a law that finds its birthplace in an apartheid system is likely to be colored by that system within which it has found its birthplace, in a system of injustice. And indeed, one will say to you that you cannot find justice, nor can you find legal justice within a larger context of injustice. And so, we will invite the Attorney General to give this country the assurance that he has not brought to this chamber and to this country the apartheid law of South Africa. That is not an assertion that I make. I invite him in the spirit that he invites of me today, a spirit of fair and academic and philosophical exchange, since he promises that he is capable of that, in spite of his associate who likes to climb on his back and shout hardest when he finishes. He would want to assure this chamber that he is quite capable of this exchange with me, to the exclusion of other unwanted guests. And so, again, I invite him to give this country the assurance that this Bail Act that he has brought here today is not apartheid law from South Africa. He did admit, the learned Attorney General did admit that it is South African law, that he brought it from there. So he will give the country that assurance. Since, apart from being a lawyer, he will convince us that he has a sense of history and he has a sense of the history of the country to which he went and brought this back to place on the parliament of this country. Now, I've looked at the legislation and it speaks very interestingly. I will start at the long title. Yes. The long title, for the sake of the public, is that title that not only introduces the legislation, but tells the public what the legislation is about and what it intends to do. Here is what it says, and the public should know this. They don't have it, I have it, and I'll read it for their benefit. It is an act intended to revise the law relating to the provision of bail or in connection with criminal proceedings and to provide for related matters. That's fine. Secondly, it intends, and it says, enacted by the Parliament of Barbados in accordance with the provisions of Section 49 of the Constitution as follows. Why Section 49, Your Honor? Now, Section 48, let me say in passing, is that section of the Constitution that gives a mandate to Parliament to pass laws for the peace, order, and good government of this country. So that anytime legislation comes to this chamber, to this Parliament, it intends to accord with Section 48. But you don't have to say that. So the learned Attorney General is correct when he brings this legislation and sees no need to refer to his inherent capacity to bring laws, to make laws, to pass laws for the peace, order, and good government of this country. But when you come to 49, that is where you must say, you must make reference to Section 49, and the learned Attorney General has carefully done that. He has said that he has brought this legislation here today pursuant to Section 49 of the Constitution. Section 49 of the Constitution is that section that gives to the Parliament the power by an act of Parliament to alter the Constitution. So that this legislation today is telling this chamber and the people of this country that the learned Attorney General is intended to amend the Constitution of this country. That's a very serious thing. When you amend your supreme law, you are doing a very serious thing. Just let me pause, and for the sake now, not of the Attorney General, who we believe knows this, the non-lawyers who will not know it. The highest law in this country is the Constitution. And that's why the Constitution itself describes itself as the supreme law. And the law that is made in this Parliament must always accord with that Constitution, so that even this Parliament is limited in terms of the kind of law that it may pass. Parliament may not pass laws that conflict or that are inconsistent with the Constitution, so that it is the Constitution that controls this Parliament. And anytime this Parliament intends or attempts to pass a law, it must be in accordance with the Constitution. But when this Parliament comes and says to the people of Barbados and to this Parliament that you intend to amend, to change the Constitution, it must state that in the legislation. And this legislation today states that in the long title, that it intends to amend the Constitution. And this Parliament has that power, because it is the Parliament of this country that made the Constitution in the first place. So if it is Parliament that made the Constitution, this Parliament has the power to amend the Constitution. But until Parliament properly amends the Constitution remains supreme and this Parliament cannot do anything beyond the boundaries of the Constitution. My difficulty, Your Honor, is that while, and I think it's section 14, now I've indicated that the long title says, promises to you, sir, that this bill will do something to amend the Constitution, because it says it comes here today in accordance with section 49. It comes here today intending to change the Constitution, and that is a serious promise. In fairness to the government, it does say at section 14 of this bill, the head note says, exceptions to section 13 conditions. And section 13, of course, would be the Constitution, section 13 of the Constitution. So that this is the portion of the legislation the Attorney General did not say. He worked me very hard, and he sent me through this legislation to find the location of the alteration of the Constitution. Very serious thing, very, very serious thing. When you are amending a Constitution by an act of Parliament, that act of Parliament must state that in plain English, that everyone understands it. Now, when they passed back in 1984, the law that allowed tenants of plantation lands to force the owners to sell to them, they amended the Constitution. And they said, the act itself says that this amends the Constitution, so that what was written in the Tenantries Freehold Purchase Act was actually a portion of the Constitution, because you can amend the Constitution by saying it in an act of Parliament. I want to ask the Attorney General to ask, I'm not going to blame him, I want to ask the Attorney General to ask his draftspersons to revisit this act and to redraft it to make it clear that this document today, apart from its long title, that this document today really and truly amends the Constitution. And that is not the subject matter of contention. Just do it, and just do it properly. So that Your Honor, the Speaker, can feel satisfied that when this leaves your charge, you can say to the public, what was done was well done. And I don't blame the Attorney General. If it is not well done, please blame your draftspeople. Go back to them and tell them that they're making you look bad in here, and that you want them the same way that the Honourable Member for Christchurch South brought you in here to pass this law. Tell them that he sent you back here to correct this law. I am not satisfied myself that it is done in the correct manner. So please do that. It may seem administrative or even clerical, but it is not. It is not petty either. It is fundamental, because an act of Parliament cannot amend the Constitution impliedly. And that is the point. A few years ago, when this government attempted to appoint a second deputy commissioner of police, and a layperson in this country, very well-known layperson, had to tell them, but you can't do it because the Police Act only allows you to appoint one deputy commissioner of police. And I well remember, the Attorney General really does not know, the learned Attorney General does not know how often I sympathize with him. I well remember him standing at the Hyatt site. I feel sorry for him quite often, sir. I remember him standing at the Hyatt site and attempting to apologize to this public for appointing a second deputy commissioner of police, although the Police Act referred to only one person that he could have appointed. And they shoved him away from the microphone in the midst of his apology. I felt sorry for him. What he was doing was right. And one of their gurus told him that, oh, a ministerial order can impliedly repeal an act of parliament. Utter nonsense. Of course, the learned Attorney General quietly came in here and amended the law because he knew he was wrong. That whoever appointed that second deputy commissioner of police was wrong and exposed the poor man to ridicule. I think they were calling him mock police or something like that. So again, that was the dilemma that the learned Attorney General has faced. Quite often, he wants to do well. He wants to do well. But doing it, for some reason, eludes him. So that I could have come here today in Shakespearean spirit and said, I know of no personal cause to spurn at him, but for the general. Now, he must not take the word general as a pun. That means for the general interest, not the general in terms of a title that someone else in this country may have. I know of no personal cause to spurn at him, but for the general. Again, he wants to do well, but he finds it rather difficult in his peculiar and particular circumstances to do well. And I will go on, before I finish this speech, to mention the constraints that this learned Attorney General, the constraints within which he operates. And I say to him sincerely, I often sympathize with him in his circumstances, not only for the shadowing that is done from East Christ Church. Everything he says, this fella, this honorable member, tries to correct and add to. Please go to your CPC for help. Don't go down there for any help. But the point I'm making is that this legislation falls short in terms of its attempt to amend the Constitution. And I want to assume that that is an error. And I want to assume that that is a genuine error. Because what the Attorney General is attempting to do here today must be done. And if this legislation falls short of doing it, I can accuse this government of deliberately refusing to do what must be done. Bail for persons who commit the most heinous offense of murder must be made difficult under constitutional rule in this country. And that is not my personal feeling exclusively. The public of this country believes that our laws in relation to the grant of bail are too liberal, and that too many men are walking around this country, repeat offenders, one murder, two murders, out on bail, and they do a third one. And the peace-loving people of this country must live with that. And a responsible parliament of this country must not live with it. And a responsible parliament of this country must come here today and to persuade this public, this country, this house, that they're intending to solve the problem. I do not believe that, having read this legislation, that it has gone far enough. And if the learned Attorney General finds that he is constrained by a constitution that is subject to the scrutiny of the High Court, the Court of Appeal, and the CCJ, what can he do? This government has 28 members. 28 members to call upon to amend the Constitution and be guaranteed 2/3. Guaranteed 2/3. And be
Honourable member, don't lose your train of thought, honourable member.
No, I'm amused.
Do not lose your train of
amused.
thought.
I'm amused. Man, send them away. I could not believe it. And you could not believe it. On the question of the Constitution, This government sits in a position, a luxurious position, in which it has promised this country a new constitution. And having promised this country a brand new constitution, although the country has sat and waited for 3 years, this government has walked around the Commonwealth and the globe telling people that they're a republic. They can't get a constitution passed yet. This country is the only country in the world that has gone republic without a new Republican constitution. I look for a challenge. It will be non-existent. But the point I'm making is this, that this, beg your pardon? This country, this government, has the opportunity to pass a new Republican constitution and deal with this issue of bail. Because what the learned Attorney General is saying to you today and what he has said in the past, he said he's not afraid of the courts. But the courts got him hopping. And his admission is that every time I try to bring a little lawyer here, they licking me. That's what he's saying. He getting lashes from the courts. And then he says, but I am frightened for them. Well, he can solve the problem. This government has been, in terms of this constitution, this new constitution, we don't know what it's about, what is in it. It has been a mountain in labor, and we await the birth of the mouse. Where is it? Where is the new constitution? But if this learned Attorney General had brought the new constitution, the question of bail, he could extricate himself and this country from this dilemma related to bail. And I will tell him what he could do under this new Republican dispensation. Because what the learned Attorney General has found his dilemma to be and to have been is that he is hopping all over the place, trying to amend this and to amend that. And as he says, every time I try to do something, the court slashing me. But he ain't frightened. He says that he's not afraid of them. It is a circumstance of some regret when there has to be a tussle between the parliament and the judiciary, and you hear government's chief legal advisor saying that he's not afraid of them, that he intends to do what he can do, and if they undo him, he's coming back again. Well, he's come back again today. And I want to politely as I can, say to him, Mr. Attorney General, what you've done today is not good enough. It's not good enough. It does not solve the problem. It does not solve the problem as to bail. We have lifted from South Africa, and I hope not apartheid South Africa, a very extensive piece of legislation dealing with this question of bail, the factors to be taken into account. There's a sense in which this so-called new legislation today does not do much more than the Bail Act of 2001. So don't come in here today pretending that this is some revolutionary piece of legislation. It is not. There's nothing revolutionary about this legislation. I am not satisfied, and you're a lawyer, sir, and you practice in those criminal courts. I am not satisfied that this legislation today has revolutionized any law in relation to bail. I am not satisfied, and I say to the public of this country, that this Bail Act today has not necessarily made it more difficult for accused persons to get bail. Indeed, what this legislation has done, this legislation has transferred the responsibility for the grant of bail to the judges. It almost becomes a trial. If you read it, sir, and I'm sure you've read it, if you read sections, and the Attorney General started to read them, from section 6 onwards, circumstances in which bail may be refused. The public of this country would have been far more satisfied if the legislation were courageous enough to say circumstances in which bail shall be refused. Though if the learned Attorney General says he's not afraid of the courts, get that new constitution, that new Republican constitution, such as you have the right and the power, 28 of you. Just the Speaker and I out here with no power in relation to that. 28 of you, you're guaranteed 2/3. Bring that new constitution. Bring a new legal and cultural and political dispensation into a new constitution. And tell the criminal element that if, as the learned Attorney General says, if you walk into a certain food court at high noon and shoot a man at point blank range, that a new constitution will tell you that all right-thinking Barbadians believe that the question of bail should be denied. Courage is the most enabling of all the virtues. Courage. And sometimes as parliamentarians, we must have the courage. As lawyers practicing in the criminal courts, we must have the courage to say to our clients, you are my client, not my confederate. I will represent your rights, but I will not defend your wrongdoings. And that is a distinction that we as criminal lawyers must learn to make, and we must do it with courage. And you don't have to be a lawyer to establish that kind of relationship of honor with the person that you represent. All of us here represent people as parliamentary representatives. And you must have the courage to say to any constituent, you are my constituent, not my consort. And if you breach the law, and if you breach the criminal law, and if you deprive another man, woman, or child of their right to life, you must become subject to the law. You must become subject to the Constitution. And as parliamentarians, as lawyers, we must have the courage to say that. We must have the courage to speak, not for the sake of popularity, but for the sake of principle. And I was hoping that we would have come here today to satisfy the public that bail, the question of bail, would make the public feel more satisfied. That when a man commits, and I'm going to quote the Attorney General, the learned Attorney General, the hideous offense of brazen murder in broad daylight, that he must render himself to justice. It was Cicero in ancient times who defined justice. And it was the Roman emperor in ancient times who defined justice, the unshakable desire of the law to render to every man his due. And whether a man is a client or a constituent, he must understand that law. The law that tries to do justice and to embrace justice. And to tell a country, a civilized country, that if you breach a man's right to life, that if you take his life in the most brazen circumstances, do we speak for popularity or is there room for principle? That if you take a man's life in those circumstances, bail is not only difficult. Yes, that bail is not only going to be difficult, but there are certain circumstances in which you will not get it. And that's how this public of Barbados feels. I know that is how they feel. I know that we live in a country in which we should not have to choose our route home because of fear of crime, because of fear of a stray bullet. That is happening in your country, Your Honor. Certain neighborhoods have lost the passage of traffic because people are living in fear of a stray bullet. And the upstanding people in those communities who have shops are suffering commercial losses. Because when a man was driving home from work, he would stop in at some of the shops. And as we say in Barbados, get a small item. And there are communities in this country now that suffer from the loss of vehicular traffic. Because those innocent people who are driving their children home through communities with other innocent children and other innocent men and women, those communities are losing the passage of that traffic. Because there's an element in this country that believes that they are entitled to put this country in fear. We are lawyers, we are legislators, and we have the power to put things right. And things must be put right. And those who are afraid to speak out against criminality in this country, I'm very sorry. I am not afraid to speak out against it. And the people have sent us to this place, not to protect criminality, but to protect the rights of innocent people in this country who are in fear, daily fear of survival. And so I recommend to this Attorney General, to this country, that a new constitution, a new Republican constitution, can save this country and can save this legal administration against judicial intervention, because Parliament has the right to pass laws for the peace, order, and good government. And a new constitution will say that, as much as the existing constitution says that. This Parliament has the power. And this Parliament, as the learned Attorney General says, must never be afraid to do its duty. We are here to defend the innocent. And if a man kills another man, the Constitution says that he is innocent. So we are here to defend the rights, interests, and entitlements of all citizens in this country. But if there is a minority, and we are satisfied that it is a minority, if it is a minority that is visiting disruption on this country, must we not have the courage? Must we become consorts with a criminal element because we want the extra vote? Or must we stand on principle and defend the rights, interests, and entitlements of an innocent majority in this country? And so I say today that this legislation has fallen short in its attempt not to make bail more difficult, but in its attempt to protect the innocent citizens of this country, the 99 point something percent of the innocent people who do not commit murder. No civilized society has a tolerance for murder. This is not a war ground. This is not a battlefield. This used to be a quiet country in which we grew up. I doubt anybody in this chamber ever saw a murder committed in his childhood, in his 20s, 30s. Never saw it. Never saw it. Today you can pick up a phone. Murder most foul. Murder most foul committed. And we as parliamentarians must come in here and be soft, because none of us has lost a son or a daughter, a mother, father, brother, sister, uncle. None of us. But the reality of the horror of criminal wrongdoing, we must become sensitive to it and to understand what is our duty as a parliament in accordance with Section 48 of this Constitution, to pass laws, to make laws for the peace, order, and good government of this country. I am not happy. I am not satisfied that this attempt today is enough. It is not enough. To quote Kamal Buffett, it is not enough. I was addressing Your Honor as to a recommendation to pass a new constitution for the protection of the innocent. Far too often, we have been concerned with the rights of those who have not been innocent. I speak for them too. I speak for their right to a fair trial. I speak for their right to dignified treatment if they go to prison. And if they don't go to prison, I speak for their right to live as free men. That if a man is acquitted at the assizes, he is free. And he must be treated not only as free, but as innocent. I speak for those rights as well. But there are many, many more who will never visit the criminal justice system, and we must speak for them as well. What has this legislation done to embrace the rights of the innocent? Very little. It has not expressly stated that it amends the Constitution, and if there's a section that says expressly that it has amended the Constitution as it must do, I apologize. But I have not seen it. Apart from a new Constitution, sir, this is probably the third or fourth time I'm saying in this Parliament my speeches are consistent. I have said in here previously that we need a new Offences Against the Person Act that creates degrees of homicide. And that would go a long way towards solving this problem of bail. There's no mystique or mystery to it. The Americans do it. You establish degrees of homicide: first degree, second degree, third degree, fourth, manslaughter. Perhaps 5 categories. And when a man comes into the charge of the police having committed a homicide, the discretion of the police officer will determine the nature and the severity of that offense that he has investigated. And he will put him into one of those categories: first, second, third, fourth degree murder, or manslaughter as the lowest of them. The policeman is intelligent enough, he investigates, he knows how heinous the offense has been. And a new Offences Against the Person Act, which creates degrees of murder, resolves the issue of bail at the time of charging. So that if the police in their good discretion and lawful discretion decide to charge a man for one of the lower degrees, the very law itself will say that he's entitled to bail. But if it is the first degree, and the police charge that man in the first degree, he knows, the country knows, everybody knows that in the first degree, bail is not an issue. So I ask this government, I beg this government, please overhaul the entire system, overhaul the entire legislation, and please create the degrees of murder so that the question of bail is resolved at the stage of being charged. I remember, sir, we've had some wonderful prosecutors in this country. When I came to the bar, I met Sir Elliot Belgrave, who became Governor General. I met Olton Springer, Mr. Olton Springer. I met Mr. Charles Leacock. We've had some wonderful people occupying those offices, and I mention them to say this because I think the Attorney General says that he is going to bring some plea bargain act. And I mention them and the civility that we enjoyed with those learned gentlemen, because you had a man...
Remember, you said you enjoyed the civility. You, honorable member?
Their civility, yes. You're saying they were not?
No, that you say you enjoyed the civility. You in the criminal court, honorable member for correction. So, you...
I don't know what you're suggesting, but you and I have been very civil.
But we were in many matters together with some of them, honorable member.
No, they were civil men, and they were very civil people. I mean, we fought hard. But as soon as we got by that doorway, we were shaking hands. And
You're sure of that, honorable member?
absolutely certain. And I will bring an anecdote to prove it. In the old days, you had a client, he killed somebody, whether by misadventure or by intent. He kills a fella, and automatically they had to charge him for murder. If in any circumstance and a person died at your hands, he had to be charged for murder. If you had the best defense of self-defense, the police had to charge you for murder. And so, having been charged for murder, they had to send him up to prison. So a lot of innocent people sat down up there, waiting to get off. The best cases of self-defense, you got to be in Glenderry, sit down up there. So that, because we had this very good relationship with those esteemed and learned gentlemen of whom I speak, two now deceased, God rest them. Sir Elliot, thankfully still with us. I think he's around the age of 90. Wonderful man. And I hope you know that. You know that wonderful man. We would go to them in a case where the man was patently innocent. And because of a good relationship, we would beg them, please charge him, please reduce the charge to manslaughter. And the reason we did that is because we knew he could not get bail for murder, he could get it for manslaughter, and because I had an excellent relationship with those wonderful men. I was at law school with Charles, Mr. Leacock, Mr. Springer, and I've never met a more affable gentleman than Mr. Olton Springer. And I was in his parish on Sunday, getting some very good results. Let the honorable member for St. Lucie know that Mr. Springer was one of his constituents. And we were down there on Sunday. The point though is that because of these relationships, we were able not to manipulate the system, but a civil relationship, a good relationship, allowed us to have the system work in such a way that our client found justice. But that was casual. That was not a lawful way, or it was not unlawful, but that was not the prescribed way. The law did not prescribe for that recourse. It was a recourse based on a good relationship. And I had one, I remember, the chap had a good case for self-defense. And I told Mr. Leacock, look, here are the facts. And Mr. Leacock agreed to reduce it to manslaughter, and of course, as soon as he did that, we applied for bail and got it. The law must now develop to a point of certainty that if a man has what we all know, or what the police may know is a good defense, you charge him for one of the lower degrees, and bail becomes guaranteed. But if, as the learned Attorney General said, if it is one of these heinous ones to which he referred, he is going in first degree. And bail then does not become an issue, and that becomes an act of Parliament. But that act of Parliament is protected by the Constitution. And there's no court under Barbados, or over Barbados, I beg your pardon, that can say that a constitution is unconstitutional. The Constitution will protect those degrees of murder. And I asked the government, since the government has been so magnanimous today to bring an act, to bring a law because I asked for it, I asked the government to be equally magnanimous and to bring to this country new legislation that will provide for degrees of murder so that the issue of bail is resolved. Can the government do that, Mr. Attorney General? Can you do that? Not for me. Do it for the people of Barbados. The same way that you've done this bail act for me, and consequentially the people of Barbados, please bring degrees of murder for me and for the people of Barbados. More importantly, though, the people of Barbados. And while the government finds itself so magnanimous, I trust that it will follow the example of Jamaica. You know, I talked about anti-gang legislation recently, and I heard elsewhere, but it has failed in Trinidad and Jamaica. That's not true. There are still gang-related offenses taking place in those countries, but those commentators are not aware that there are people in those countries being charged for their activities in relation to gangs. And if they want evidence, I take them to Bermuda, in which persons have been successfully prosecuted. Persons who have not been on the scene can be prosecuted because it is known, evidence is given of their relationship to the immediacy of the crime in question. Is this government afraid of that? Will this government find itself afraid to pass anti-gang legislation? Will this government find itself afraid to create a gun court? And if you are so afraid, you're occupying the office of government without justification. This is not a personal plea now. This is a plea made for the sake of peace, order, and good government in this country. Please find it possible, government, to pass a law that creates a gun court so that this abundance of gun offenses will find themselves being tried in a court dedicated to that, one or two courts, and that a man will not be on remand for 24 months, and then you have to release him because of what the appellate courts say, but that perhaps within 12 to 18 months at the most, if you have a gun, you're before a court. If you're charged for any gun-related offense, you're before a court in a hurry. I want to recommend that a gun court may do that, may assist the administration of justice in resolving that issue. None of us enjoys crime. So apart from the creation of the degrees of homicide, a gun court, this is not an occasion for me to repeat the call for anti-gang legislation. If the government is afraid, well, you forfeit the right to be government, to describe yourself as government. But, you know, we find in this country that government is playing hopscotch with the issue of crime. That there are some things that the government seems reluctant to touch. And you will appreciate the hopscotch analogy, sir. When we were young, we drew that hopscotch court. 8 boxes, and you wet the paper, or you wet the cloth, and you throw it. And it taught you to hop on one leg, and it taught you to balance, and you hopped. 1, 2, 3, 2, 1, 2, and you missed the box in which you threw the object. And that is why I use the hopscotch analogy, that this government is hopping around the issue of law. This government is hopping around the issue of criminal law. And it is avoiding the most urgent of the boxes. The boxes that deal with pervasive and violent crime. And you know, sometimes you go to the court and some minor offense is taking precedence over a murder case. And I don't understand it. I don't understand it. I asked the government to stop playing hopscotch, to get rid of the wet cloth, and to hop in all the boxes. Whether it is murder, gun, manslaughter, firearms, hop in every box. If I hear one sound, I'm going to say something. One sound, I will say it. I will say it. I will say it. Thank you. You see that relationship with the police, sir? I said before, and I say it again, that this government has lost its police service. There must be, in any country that intends to pursue peace, to establish a relationship of harmony with its police service. Can we in this country now be satisfied that the relationship between government and the police service is harmonious? Can we now be satisfied about that? And I heard a sound, and I will say this. Is it for any member of this government to be disclosing policy that ought to be disclosed exclusively within the police department, either through the commissioner or a delegated or designated officer? The government has no business in the internal affairs of the Barbados Police Service. Certainly not in terms of its policy, its internal policy that is intended to suppress crime in this country. And if this government or any member of this government from top to bottom is making these disclosures as the internal police policy, the citizenry must become nervous and wonder who is running the police force, the police service. It has to be the commissioner, not the Attorney General, nor the Prime Minister, nor any member of this cabinet. Because it is a dangerous specter that hangs over a country when members of a cabinet appear to be involved in the internal workings of a police service. The public will become concerned because they will wonder whether criminal charges will be based on partisan association. That is the danger that we face in a country that claims to love its freedom. I ask this government to butt out, to get out of the affairs of the Barbados Police Service. And if the Barbados Police Service wants to create sections within its operations, that is the business of the police. It is not the business of a politician. Do we find it so hard to understand that? Or do we give justification to dictatorship? Because that is the specter of dictatorship. When a government trespasses into the Barbados Police Service and makes determinations and announcements as to the creation of divisions meant to deal with crime, crime is not the business of the government. What is the business of the government is legislation to guide the police service. What is the business of the government is legislation to control and to suppress criminal activity. But the workings of the police service belong exclusively to the police service, and Section 8 of the Police Act is always a reminder that in the superintendence of the Barbados Police Service, the Commissioner of Police is answerable to the head of state, not the head of government. You know, tyranny, as the old people used to say of trouble, it doesn't set up like the rain. You don't look up and suddenly see dark clouds. Tyranny sneaks upon you, and you're accepting, and you tolerate certain actions until one day you discover that those incremental actions result in the taking away of your freedoms. And I ask this government, to reverse itself on the issue of what appears to be unlawful participation in the internal workings of the Barbados Police Service. And if it does not, the citizens of this country are entitled to start believing that they will be exposed to police scrutiny on the basis of partisan affiliation. Because when a politician becomes involved in the internal workings of the police force, the rights of the citizens and the political rights of the citizens become at risk. I beg this government, I ask this government, I beseech this government, I plead with this government to withdraw its tentacles, to withdraw its voices. They may even believe that their voices are legitimate, insofar as they reflect the internal workings of the police service. But let the police service do its work. Give credence, give credibility, give authority, legal and moral, to Commissioner of Police. Let him do his work. Let the deputies do their work. Let the assistant commissioners do their work, and the superintendents at all levels. Let them do their work. Let it not be a subject matter of political declaration and disclosure. Let them do their work. I have to shout at that point, because freedom is under threat in this country. Freedom is under threat in this country. Freedom is under threat in this country. When a politician begins to make disclosures about the internal workings of the police force, intelligence gathering, etc.
Mr. Speaker, I'm raising a point of order.
Right, trustees.
The path that the honourable member is going down is irrelevant to the current matter before this chamber. We try to ignore him in the hopes that he would, burn himself out and stop. But this is irrelevant, and that's a legitimate point of order. It's irrelevant to the debate in front of the House. And he has been on this track for the last 11 minutes. 11 minutes, sir, of complete irrelevance to the new bail legislation. I ask, sir, that you guide him. Otherwise, we may be here tomorrow.
And on the question of bail, Your Honor, under this bail act, under this new bail act, the police enjoy a discretion. And the Attorney General dealt with that as he brought this act before the court. We were just talking about the issue of bail. We were just talking about the issue of the police in relation to bail. And the honourable member who just took his seat will now wish to be aware that this act gives powers to the police. He will be invited to Section 5 under the rubric police bail. And whether the police grant bail or not is not a matter for a politician. It is a matter for the police. We are discussing the bail act. You can say as much as you want. I'm going to teach you today. Please read Section 5. Please read. Attorney General, Honourable Attorney General, please direct your shadow to Section 5 of this legislation.
Honourable member, you can't use that phraseology in here, but asking the Honourable Attorney General to speak to his shadow, that is unparliamentary.
Yes.
Totally.
I don't know why I slipped. I meant his colleague. Please direct his colleague. I abide by your rule, sir. Please direct your colleague to Section 5 of this new proposed legislation, which speaks of the question of the police having the right to grant bail, and that if a politician becomes involved in the internal workings of the Barbados Police Service, every aspect of police powers becomes potentially, and dangerously, subject to the whims, the caprice, the will of a politician. We are on dangerous territory, Honourable Member for Christchurch East. Through you, sir. We are in dangerous times. And all I am doing is asking your government, through the learned speaker, through the honourable speaker, to remove itself from the internal workings of the Barbados Police Service, whether it has to do with bail or being charged, and we shudder to think of this. And so shuddering to think of it, I shan't mention it. But, Honourable Member, through you, sir, please, I beg you, on behalf of the freedom-loving people of Barbados, please, as a man of honor, please persuade your government to withdraw itself from the workings, the internal workings of the Barbados Police Service. Please, I beg you. Please, I beg you. But in so begging you, I return to the specifics of the legislation. I don't know why my colleagues suffer such discomfiture at this point. I don't know why there's this eruption. I don't know why there's this protest. The length. It's the length. He doesn't want to hear the truth any longer. And he says he doesn't want to hear the truth repeated. I will not concede to his plea. I will continue to speak the truth. And I will say, in summary, to the learned Attorney General, through you, sir, that this legislation, whether it is apartheid legislation or post-apartheid legislation, that I don't think it has satisfied the people of Barbados, that certain categories of offenders under this law will be remanded to a prison mandatorily. It leaves the responsibility on the court. There is a long, convoluted process, almost a trial in itself, in which a bail application is now like a trial. It places the burden, the responsibility on the judges to determine whether a man should have bail, whereas previous legal dispensations, parliamentary dispensations, acts of parliament, used to determine that bail would be denied in certain circumstances. We must have courage. We must have courage. And it is not that a parliament intends to erode freedoms, but it is that a parliament intends to create a society that is peaceful, where the majority can live peacefully. To the Attorney General, I say I accept your magnanimity. I even accept your graciousness. But I find it difficult to accept that this legislation today does what you say it intends to do. I don't think it does. And if the learned Attorney General can point me to that express statement of amendment of the Constitution, I will accept it, even with apology. This does not do what it says that it will do. I ask this government to seek to re-establish a harmonious relationship with the Barbados Police Service, if it is at all possible. I suspect it is too late. I suspect that time has gone. They complain that I repeat. Some things are worthy of repetition. This country is on the precipice. This country is on the precipice. And as I say to young criminal lawyers, I say in this parliament, your client must never be your confederate. I say to young politicians, your constituent, who does wrong, criminal wrong, is not your consort. You will represent him with no less zeal, no less vigor, whether it is in the court or the public domain. But confederacy and consortium with criminality by people in our responsible positions is a breach of that social contract that we make with this country. It is a breach of that contract of the ethics of the profession of law. And I warn my colleagues on both sides of the political divide to do nothing that appears to give comfort to those involved in crime, whether actual or by proven reputation. That is as much as I say. I am serious about this. I am serious about this, the pursuit of popularity has its price. The pursuit of popularity, when it engages confederacy and consortium with undesirable elements, results in a price paid not by those of us who do wrong, but an entire society suffers. And we in this country can all see what is happening in this country. We in this country can see what is happening with people, with babies in this country. We saw the video. We are on the subject of crime. We are on the subject of the scourge that is crime. We are on the subject of the social ill that is crime. This legislation today relates itself to the suppression of crime. And can we not see as a country what we do to this country when we breach our responsibility as legislators, when we breach our responsibility as lawyers, when we breach our responsibility in public service generally, and abandon our duty to law and to justice? This is a serious message. This is a serious message not only to the public of this country, but to this parliament. And I haven't come here, as the learned Attorney General said today, to involve myself in any blood sport. The learned Attorney General asked me today to join with him in ensuring that this country can once again be a peaceful place. Can any one of us in here today look into the face of a constituent and say that this country is peaceful today, when the smallest of our children have found themselves fallen into an abyss of moral decay? And that moral decay often leads to criminality, because there's an element of crime, always an element of crime that is immoral. So that when I speak of bail, I am entitled to speak on the issue of crime that is destroying this peaceful little place. People 70 and 80 and 90 cannot believe that this is the same country. They can't believe it. And they don't want to disturb previously held beliefs as to the stability of this country. And so they don't leave home at night. They fear the night. And as I have said, they fear certain routes home. And women in this country Women in this country are now having to travel the long road to go home at night. And that is why the question of bail remains important. That is why you cannot have Your Highness wrongdoers on the streets of this country preying on women who happen to be driving a car alone. They follow them from the supermarket. And you tell me bail is not important? And you tell me that people who flout the law and flout the rights of people to live in a civilized community, and who sometimes kill them, and we then come in here and play games? I don't want to say we go to the courts and play games. We don't play games there. But the learned Attorney General has given the assurance that this is no blood sport today, and I agree with him, it's no blood sport. This is a country on the precipice of disaster. And I repeat, the proof of that disaster is on our very phones, Your Honor. One time you had to go into the community, the larger community, to see the wrongdoing. It's now televised on our phones. So that when the Attorney General says that this is urgent, I agree with him. Somewhere I read about the urgency of now. This has to be done now. This has to be done today. What this Parliament is doing today has to be done today, and I'm obliged to him for answering what I think is a legitimate call, although it came across the partisan divide. He is gracious enough to concede, to admit, to state that he brings it, the learned Attorney General brings it further to a call that I made. But I am not consumed with immodesty, vanity, nor conceit. What I would say, Your Honor, is that I believe that the learned Attorney General brings it because he, in his peculiar and particular position, knows that this country is in peril. He knows that. So it has nothing to do with any personal transaction between he and I. It is his knowledge, it is the knowledge of the learned Attorney General of this country that we are at the precipice. And therefore he lifts legislation from South Africa to save what we hope is not an impossible position. There are too many wrongdoers among us. In the car that passes us, on the motorcycle that drives past us, in the supermarket aisle as we shop, on the streets as we walk. They're all around us. They are with us and we are with them. What is the resolution? What is the resolution of this Parliament? The learned Attorney General says, not a blood sport, and I agree with the learned Attorney General. It's not a blood sport. Let us find a way. And if he doesn't mind, I will say it again, this is not the way. This has not gone far enough, and I summarize and close by asking the learned Attorney General to get the new Republican Constitution to this Parliament and to do it with haste. And to get that Republican Constitution to this Parliament with haste and to get it here with a content that does not disturb the fundamental right to freedom that protects bail, except that I ask this learned Attorney General to bring with that new Republican Constitution a new Offences Against the Person Act which creates degrees of homicide so that the question of bail is determined when a man is charged. And solve this problem. Solve this national problem. Resolve this national scourge. And after this learned Attorney General has done that, to bring a gun court to the administration of justice and to bring anti-gang legislation to this country and to rein in rampant criminality that visits us in our daily lives. A lot of people are walking around this country in fear. And any parliamentarian in here that tells you that he is insulated from the high incidence of fear that Barbadians feel in their social spaces. People are walking down the street in fear. People are walking into supermarkets and are afraid to brush somebody's shoulder accidentally. They do not know what is the response they will get. And a certain store owner spoke to me recently. And I asked him to explain this fear, because he sees thousands of people every week. And he gave an answer. And it is one of the answers that I want to give to this government. I asked him, why are people so angry? And he said, but don't you think people would be angry if they're hungry? So that one of the solutions to the problem of crime in this country is socio-economic reform. Socio-economic reform. It is not only military, it is not only legislative, it is not only cultural. But we need an economic safety net for our vulnerable people. A lot of the people involved in crime, a lot of the people coming before the courts, a lot of the people being admitted to prison, a lot of the people being refused bail, a lot of the people who get bail belong to that vulnerable portion of society. If there's anything sympathetic to say for those involved in crime, it is sympathetic, but it is not supportive of crime. So that the laws of this country need large overhaul to protect the innocent in this country. Again, I say, Your Honor, I am not satisfied that today's legislation will do enough. Well-meaning as the Attorney General of this country, well-meaning as he is, living with no fear of the courts, I can only graciously say to him, the Attorney General of this country, it is not enough. It is not enough. It has not done enough. It will not do enough. It cannot do enough. Your Honor, having said that, I give the intent my support, the intent. But what I have actually seen, I cannot be supportive. I cannot be supportive. If it were urgent, and if it intended to confront the problem of bail as it relates to recidivistic criminality, if it intends to do that, I cannot support it. It has not, in spite of its intent. I want to say this in the kindest and most polite way I can. I believe this will fail. I don't believe that it will solve the problem. I meet today's legislation with disappointment that once again, it is throwing too much of the responsibility on the courts of this country. The question as to factors to be taken into account on the grant of bail, all that you export to the judiciary. You ask the judiciary to deal with it. This Parliament makes the laws. This Parliament could have made a law that was resolute, that was firm, that was certain. This Parliament today fails to do that. And we are back in the hands of the judiciary. Not that the judiciary is an unsafe place, but the judiciary itself says that it is Parliament that makes the laws. They say that. You and I know that's a legal fiction, because they make laws as well. But we are the primary, this Parliament, a Parliament is the primary source of law after the Constitution, except that even the Parliament makes the Constitution. And imbued with the legislative power, the wide legislative power that this Parliament has, may I kindly say that this Parliament today has breached its responsibility to this country, and that this Parliament has not been firm. This Parliament has not been resolute. This Parliament has given birth to a failure, a legislative failure today, that has not adequately and properly addressed the question of bail. That once again, we are in the hands of judicial discretion. Maybe that is safe territory, but we don't operate on discretion up here. We operate on a right to pass laws for the peace, order, and good government of this country. Today we have reneged from that right to pass laws, to pass a law, to pass a bail act for the peace, order, and good government of this country. Have we been afraid? Have we been afraid to exercise the powers that this Parliament has? While being not afraid to infringe on other civil rights that the people in this country ought to have, while not being afraid to trespass on policing in this country, this same government today comes here and passes a cowardly piece of legislation, or attempts to pass a cowardly piece of legislation that will do far less than a gun court would do, that would do far less than anti-gang legislation would do, that would do far less than the creation of degrees of homicide. This government, when it suits it, is conveniently cowardly. And when it is politically expedient, it will have the courage to do wrong against the people of this country. Does not have my support. Does not have my support, Your Honor. I'm obliged to you.
Honourable for Christchurch East.
Mr. Speaker, I rise in full support of this legislation. I have, sir, the enviable task of coming behind somebody who can complicate and confuse the more simple.
Excuse me, beg your pardon. Somebody, Your Honor, somebody. I am told to address my colleagues with respect.
But Honourable Member for Christchurch South, he hasn't, I've not heard the Honourable Member say anything yet.
He called me somebody.
No, he never said,
You see, coming behind somebody.
but no, Honourable Member, no, I've not heard the Honourable Member for Christchurch East finish his sentence, please.
Okay, well, I hope he
Please.
abandons the sentence.
Please,
If he called me somebody, he's free to call me nobody.
Honourable Member,
But please let him refer to me as you would wish him to refer to me.
Honourable Member, there's no reference made to you. No reference has been made to you, Honourable Member.
As I said, sir, it is not easy. But the one thing I realize, sir, and the reason I choose to come behind the Honourable Leader of the Opposition is sometimes, sir, in the same way that the Sanitation Service Authority positions itself on Kadooment Day after the last ban, and comes right behind it, sir, to clean up the road and to get it fit for use again as immediately thereafter as it can. I find myself, sir, in that position quite often. I realize, sir, that the Honourable Member has a routine, almost like an agenda. You know when you go to a meeting, they have an agenda? His routine, sir, established and confirmed today, is he starts by getting up and waffling for about 5 minutes. He then says that the AG did not do anything. This is standard. Waffle, then criticize the AG. Then he misquotes the AG in order to grab a headline. This is standard. I then get up on a point of order. The honourable member then gets upset and throws a tantrum, and then spends the next 5 minutes thereafter attacking me. And then, sir, he throws in a quote from Shakespeare just to be good. If we actually look at his last series of speeches where this order has obtained, sir, this is exactly the agenda that follows. He threw in the speech on Shakespeare, this time, sir, from Julius Caesar, in reference to the AG. I know of no personal cause to spurn at him, but for the general. Sir, I also want to help to educate him of one of my favorite quotes from Shakespeare that also dealt with the treachery and betrayal of a trusted person. And it talked about life, but you can substitute the word life for anything else, like leader. Life, sir, or leader of the opposition, is but a walking shadow, a poor player that struts his hour upon the stage and then is heard from no more. It's a tale told by an idiot, full of sound and fury, signifying nothing. So, if we quote in Shakespeare, let's trade quotes. I will note yours.
Honourable member for questions? No. The point of order? Is there a point of order?
I don't mind the quote.
No. Is there, you can only raise on your point of order.
Yes.
What is the point of order?
Offensive speech.
I will not. Continue, honourable member for questions, please.
Yes, let him continue.
Continue.
Interesting, sir, that offense was taken where none was intended. I simply traded a quote for a quote. But who the cap fits, let him wear that another quote. Sir, my level of confusion following during the address of the Honourable Leader of the Opposition, sir, was due to the blatant inconsistency in what he's saying. On one hand, he says that the government was cowardly and timid. It didn't go far enough. It did not take the opportunity to go far enough. On the next side of his mouth, he talks about having regard for the right to liberty and the right to freedom, that this may be inconsistent with that right, but still talks about we did not go far enough. So I listened carefully because I was actually waiting to find the points of contention with the actual legislation to then deal with them one by one. After, sir, wandering all over the place to talk about everything under the sun, when the Honourable Leader apparently accidentally collided with the subject matter, then, sir, the only complaint, the only comment about the actual terms of the bill, or the clauses in the bill, was to say that the part defining section 6.1, circumstances in which bail may be refused, should actually be circumstances in which bail shall be refused. We missed the perfect opportunity to make it mandatory as opposed to permissive. That, sir, if you actually shift out all the irrelevancies, all the tangential discussion, all the fluff, that, sir, was the only constructive comment in relation to the entire piece of legislation. Now, let me help the honourable member, sir, who seems to have forgotten all of his legal training. The reason that the last amendment was struck down by the court was because the court was of the opinion it interfered with the discretion of the court. It gave a mandatory position that the court had to follow, that effectively, as he's talking about the arms of government and separation of power and interference in the police service, effectively, Parliament attempted to fetter the hands of judiciary. Parliament attempted to tell them what they have to do in a particular circumstance. Sir, I contrast that reasoning of the learned Justice Griffith with the last contention by the Honourable Leader of the Opposition, that we should take it out of the hands of the judges, that this government should be bold enough to make that decision itself and remove it from the hands of the judges. I do not know what court of law in Barbados he practices in. I do not know. I do not know if you read the decision of the court. And perhaps, sir, some things you cross principles. Sometimes you look at a principle that everybody is familiar with to explain another principle. The same separation of powers and discretion of the judiciary and federal judiciary was the whole basis for striking down the mandatory death sentence. The law, the court, all the way to CCJ said, hell, you could order death sentence. The death sentence can be on your book. We're not telling you can't hang. But the legislature cannot tell a court, if you find this, then it has to be that. That went all the way to the CCJ. That is pellucidly clear as law. The reasoning is sound. That was the exact same reasoning that the court used to strike down the other provision. So for the honourable member to come and stand up in here, and grandstand as if spouting some new form of law, as if airing his letters KC before the world. If we did what he was suggesting that we do, we would be back in the exact same position as we were when the court struck it down. Or in the exact same position when they struck down the mandatory death sentence. I sometimes wonder, sir, if the Honourable Leader tastes his words before he says. You know, sometimes you think to say something clever, but if you actually voice it first and listen to it, you realize it sounds stupid, and you backtrack from that.
Please allow the
Sir, the honourable member spoke about there being nothing revolutionary in this. No change. It ain't add nothing to the last piece of legislation. It will not attract any difference in its application. Sir, I am convinced, no, he didn't read it. I am convinced. The issue, sir, the issue confronting the public on which there was public outcry was the fact that bail was being granted to people who were convicted or who had charges for murder or firearm offenses. That was the public discussion. It was clear. Everybody in Barbados knows it was that. People.
Remember, please. No, you can't speak from there. You spoke for your time. Please allow the honourable member Christchurch East to speak.
Sir, let me help you. He didn't just speak for a long time, he spoke ad nauseum. And the focus being on the nauseum part. Sir?
You know, I remember there's a marshal sitting out there who has no work to do, you know. I remember there's a marshal there who thirsty for work. He's thirsty for work.
Sir,
he's thirsty for work.
The argument and the contention was made that nothing different has changed. All of us in here to a man either heard or identified with the outrage of the Barbadian public in relation to the campus trials killing. Let's pick the common ones. All of us in here to a man were in shock and horror when the shooter went into Sheraton Mall and shot at the place, reckless as to who was endangered. All of us in here were in horror when they had the Kadooment there shooting that injured a whole ton of people. And people in Barbados said, I hope that man don't get bail. In each one. We have heard instances of persons being out on bail when they had 2 pending murder charges. Persons being out on bail, sir, with multiple firearm charges. And the public of Barbados with one voice said, and we listened, how can we have faith in the system when somebody on gun charges, somebody on murder charges can go to the court to get bail? We tried to do it in 2019 with the 24 months. That was struck down. Since then, certain things have gotten worse. I admit they've gotten worse. The Honourable Leader of the Opposition said they've gotten worse. We were in discussions about what to do next. How do we deal with this? This came up in Cabinet, it engaged the parliamentary group, it engaged the whole of Barbados. The Honourable Leader came in here and said that he is not about pride or vanity. Sorry, he missed a word. The word is hubris. It is hubris, sir, to think that we as a government are responding to him to correct a situation that we all know exists in Barbados. This government is doing this to secure the integrity of our systems in Barbados. We are doing this to ensure that our judiciary and our judicial system is respected. We are doing this that when people see heinous crimes being committed, they have comfort that the decision taken in respect of bail is going to be reflective of the public outrage and the public outcry. We are not doing this in relation to a request from the Leader of the Opposition. It might surprise him to know that he does not even come up in our discussions. We had to recognize him in some way when he was on one side of the fence. But from the time he crossed, sir, it solved a problem. We now don't even have to acknowledge him. But let us talk about revolutionary. Let us talk about revolutionary. As it stands now, and this is so the public of Barbados can understand, when a man is charged and he goes into the court, his lawyer will stand up and say some usual things. He will say, he's a good fella, he has a job, he's his sole breadwinner, he's not a flake race, he got 10 children, he provides for them, and. No evidence is given. No evidence is given. The lawyer will say all of that. The prosecution then gets up and they say, if he's released, he may interfere with witnesses. We had sufficient time to complete the full investigation. The gun has not yet been recovered. Make their arguments, and then everybody sits down, and the judicial officer then makes a pronouncement. Either bail granted with conditions, or bail denied, accused remanded. That's it. That is it. So as it stands now, when we see someone charged and appearing for bail, and the judge, in circumstances when the whole country, everybody is watching, saying, he can't get bail. That man he cannot possibly get bail. No. If that man gets bail, the judicial officer has, at the time of granting bail, to give written reasons for his decision. He has to say why. He now has to explain to all of us, and it's a matter of public record, what informed your decision in granting bail to this person that everybody feels should get locked up. It would be a brave judicial officer that does not exercise his mind judiciously and bear in mind the responses of the public. That is as revolutionary as it gets. Back before, the public concern, the public outrage, the whatever, that was not a factor for the court at all. At all. It is now a factor. Another factor. I've been in practice for 27, 28 years. The Honourable Member has been there before me. 40 years. Fine, sir, 40 years. For 40 years, sir.
Listen not to the honorable member.
No, sir.
Listen not. Exercise judicial deafness from the honorable member.
No, sir, I'm actually silently reciting the serenity prayer, sir. I got to the things that I can't control, and I'm just like knowing the difference, okay? Sir, in my entire time in law in Barbados, I have never once, not once ever, seen the prosecution attempt to appeal a decision on bail. I don't know if they didn't have a right. I didn't see it in the last piece of legislation, but I know that I have never seen an appeal from a bail application. It is not even common. It is now embedded in this legislation. If, against all the odds, somebody who commits a heinous offense, who is previously known to the court, is granted bail, the outrage doesn't just stop there. The prosecution now has a right to appeal, a right to take it a step further, to let the decision of the judge be reviewed by a higher panel. If that is not revolutionary, I don't know what it is. What is? Sir, it perhaps helps if I actually, the Attorney General did it in his statement, but I'm going to do it now in this context, having explained that. Sir, under circumstances in which bail may be refused, it gives a whole series of things, sir, the normal ones, but then there's this critical one. Where in exceptional circumstances, there's a likelihood that the release of the defendant will not be in the interest of public order or public safety or public security. Now, what does that mean? The other revolutionary thing in this piece of legislation is that it sets out the circumstances in which bail may be refused, is A, B, C, D, E, right? Section 6(2). If you had read it, you would know where it was. It sets out, sir, the circumstances in which bail may be refused and itemizes them. But then it goes further. It did something I have not seen before in our legislation. It then sets out the examples under each of those circumstances. So for the one I read before about the public outrage, sir, let's go to that. And for the benefit of the honorable member, that's at section 6(7). In considering whether the ground in subsection 2E has been established, the court may, where applicable, take into account the following: whether the nature of the offense or the circumstances under which the offense was committed is likely to induce a sense of shock or outrage in the community. Well, if that's not the campus trends, fire. If that's not the shooting in Sheraton, sir, I don't know what is. Whether the shock or outrage of the community might lead to public disorder if the defendant is released. The judge now has to address his mind. Is the public outrage, it now has to put itself in the mind of the public. Is the public outrage so much that people may actually revolt against this? It considers whether the safety of the defendant might be jeopardized by the defendant's release if somebody can extract vengeance against him. Whether the sense of peace and security among members of the public will be undermined or jeopardized by the release of the defendant. Is this somebody that the public of Barbados feel, if this person gets back out, I might be in danger? The court has to consider that now. It has to consider whether the release of the defendant will undermine or jeopardize the public confidence in the criminal justice system. If the crime is so heinous, it's so bad that we all said, oh my God, not here in little Barbados. The judge now has to apply himself, apply his mind. Is this something that I can overlook in granting this person bail? Sir, any other factor which in the opinion of the court should be taken into account? Sir, the court also now has to give written reasons for its decision. So it's not just that criteria exists. It's not just, sir, that the application, the criteria is spelled out, but the judge now has to put it down in writing. the judge has to write it knowing that his or her decision is reviewable by the Court of Appeal all the way up to the CCJ. They have to show that they considered all of these in making a decision whether or not to grant the bill. If they grant the bill where these circumstances exist, they must be prepared to explain to a court above or to the people of Barbados what possessed you, the judge, to give this person bail when nobody else in Barbados can see it. And I hear the noise that I'm not supposed to be hearing, talking about more hard work, more hard work, more hard work. There is no such thing as too much hard work to protect the people of Barbados and our institutions. If the honourable member, sir, was not averse to hard work, he might, sir, have chosen to pick up this beforehand and read it. He might, sir, have chosen to accept the invitation of the Honourable Attorney General, which sought to explain. He might, sir, have availed himself of the opportunity to benefit from the explanation of the Honourable Attorney General that neither he nor any of his two opposition senators actually took on. He might, sir, have chosen to educate himself instead of coming in here, sir, to confuse people. The last 20 minutes of the Honourable Leader of Opposition speech was complete fear-mongering. He talked about following people in the supermarket, people having to drive the long way around, right? Being afraid to walk in a car park. It was fear-mongering to the extreme. And yet, when asked to comment on the bill itself, the only thing he would have done was change the word may at the top of section 6 to shall. So when he asks, why is it that I keep coming behind the Honourable Attorney General? I don't come behind the Honourable Attorney General. I come behind the Honourable Leader of the Opposition. Because, sir, nonsense must not be allowed to permeate and gain traction.
Honourable member, please, please. Marshall, get ready.
Hey, so, you know, the closest thing I could call these interventions to mind. So, you know, sometimes when you flush and you watch and it doesn't all go on, you flush again and it keeps coming back up and it keeps coming back up, it keeps coming back up. To be honest, sir, it is annoying if it wasn't funny. Sir, the Honourable Leader of the Opposition, in trying to justify what he was saying, said he recommends certain things. That this legislation ain't doing it. He recommends a new Offence Against a Person Act, which says degrees of homicide, a new gun court, a new constitution, a new whatever. He then said, this bill needs to be done today. It is important. His words, this bill needs to be done today. The same bill he was saying did not go far enough. The same bill he was saying impinges on rights and freedoms of a person. The same bill he was saying, sir, that should take the responsibility from the judges and put it back in Parliament, which the Court of Appeal, which the CCJ, which everybody has said is contrary to good governance and order. It is almost like the words sound good and you just spit them out without actually stringing them together, sir, to make a cohesive pattern that somebody can follow. So, I feel sorry for him, sir, because, you know, sir, when persons are put in solitary confinement in prison, we tend to put them under suicide watch. Because we know that loneliness is a dangerous thing. It plays on the mind. When you don't know who you could trust, when you have no friends, when the people who are supposed to be behind you are sharpening their knives for you, so it plays on your mind. When you come in this house, sir, and there are 29 intelligent people in here and you're the other one, sitting by yourself, isolated in a corner, it plays on your mind. When you start looking for friends in here when you ain't got none, it plays on your mind. So I feel sorry for him sometimes, sir. But My sympathy, and I'm a bleeding heart. I'm a bleeding heart, sir. But my sympathy for him cannot allow him to get away with misleading the public. Sir, I'm misquoting to make a point. No, I just actually don't say everything on my mind. I choose to give the ones that are relevant. So sometimes I'll pause and think, which you should try it sometime. Sir, the critical thing here, the thing that the public of Barbados was crying out most for is why. Please explain to me how this person got bail. If we narrow it down, it was please explain, you the court, please explain to me how this person got bail. This new Bail Act requires the court to give its reasons in writing. If we are not satisfied, if the prosecution is not satisfied, if the public of Barbados is not satisfied, sir, then it can be appealed and the correct decision granted. So, we recognize there was an issue. We recognize that the existing legislation did not go far enough. We recognize, sir, that the public of Barbados was feeling very concerned about persons with a criminal history and a criminal record being admitted to bail. We recognize, sir, that persons were losing some faith in the judicial system and the judiciary. And we took steps to clarify that. I will give one more point, sir, that should give the honorable member some comfort. Even in the circumstances where a prosecutor does not object to bail, the court still has to apply itself to the reasons stated. So if I read for the honorable chamber, I'm not even reading or trying to educate the honorable leaders, sir, because there's some people that are beyond salvation. So section 6.9. Sir, where the prosecution does not oppose the granting of bail, the court has the duty imposed by Section 8 to weigh the personal interests of the defendant against the interests of justice. As it stands now, and we know the practice is, if for some reason the prosecution comes in there, and this is to stop, sir, unscrupulous lawyers trying to cut deals with DPPs and prosecutors and going outside of the jurisdiction of the court to try to make arrangements beforehand. I mean, I didn't know anybody would actually stand up on record and say that they were party to that, but let's go with it. Sir, even in the circumstance, sir, where the prosecution says, I don't object to bail, the judge still has a duty to put himself in the shoes of the public and decide, is this somebody that should actually get bail? Is this something that we can explain and justify to right-thinking members of society to help them feel comfortable in their beds that justice was served and the interests of all were balanced in this? Sir, I don't want to go through, a lot of it, sir, are the regular things that came up. The specific interventions and applications from the South African legislation, sir, were to correct that part that I referred to before. And just for the benefit of the member, this is not apartheid legislation. This is not legislation passed to downtrod or keep down a specific class of person. This, sir, is legislation meant to ensure justice and deal with a particular situation. As he knows, as we all know, sir, law is about precedent. There is no need, sir, to reinvent the wheel. Anytime you're doing a case in court, so you look to try to find out, has a similar point been made before?
On a point of order, sir, would the honourable member, if he refers to the South African legislation, would he want to give the ear?
Sister, that's not a point. Honourable, there's
Thank
not
you
a point
very
of
much.
order. It's not a point of order.
He could
Honourable.
give the ear. Give the ear, son. Give the ear. Satisfy the public.
Mr. Speaker, I don't have to laugh with him or laugh at him or to actually shed a tear for him. But sir, this is as serious as it gets. This is as serious as it gets. We know, sir, we know in doing a case, in preparing a case, and the same applies to legislation. You look for somewhere where it has been done before. What was the decision? What were the arguments to and from, right? For or against? What can I extract from this that may help me? When we look at legislation, sir, unless it is something peculiar to us and it hasn't been dealt with before, we look for examples, sir, outside. And we adapt the legislation to suit our personal circumstances. Sir, in looking and considering a number of pieces of legislation, this is the one that found favor. This is the one, sir, that most found favor for us.
Honourable Mayor, ignore. Soon for now, he will place some. Honourable Member, soon for now, if he continues, he will be placed somewhere else outside of this room, so you will have to hear him at all.
Sir, it is not even.
Hold on. But Honourable Member, I will exercise my discretion. I am vested with the discretion that the court is vested with. So you can't tell me St. Thomas and St. Lucie. I have that discretion, sole discretion.
Sir, my difficulty, sir, is that with all the fear-mongering, the point is I'm looking at you and addressing you respectfully, sir, as I'm supposed to do. But out of the corner of my eye, I'm seeing gesticulations. I don't know whether, sir, he's getting a seizure. I don't know whether he's getting a panic attack. I don't know if he's about to jump across here, sir, and do something strange. So that's why I keep getting, I just have to look and verify that he's still where he's supposed to be and restrained. But sir, we are comfortable. We are comfortable, sir, that the situation occasioned by the striking down by Justice Griffith of the existing conditions that required somebody to be held for 2 years, 24 months before being considered for bail. That yes, the Court of Appeal is supposed to give us a decision. There's a decision pending from the Court of Appeal. But this is effectively made moot that point. There's really no reason for them to give a decision now, because the government has taken steps to deal with that some other way. And just for the further advice of the Honourable Member, why are we going for 2/3 majority? I personally, sir, do not believe that this legislation offends any part of the Constitution as it now stands. I personally don't believe that. Right? You get the arguments before and for and against. But at some point in time, it is the nature of legislation, especially legislation relating to criminal justice. It is the nature of legislation that somebody's going to apply. Because it is going to impact on somebody's liberty, and somebody is going to appeal the decision. When that decision is appealed, a court must be able to know that if it even looks like if it is offending any part of the Constitution, that this was not passed by a simple majority. This was passed by a majority in Parliament, the same majority that would be required to change the Constitution if we were trying to change the Constitution. So this is paying it forward. This is saying to all and sundry, we are taking this so seriously. We are so vested in this. We accept it touches and concerns the rights of individuals. We do not believe it conflicts with the Constitution. But in the event that it does, the majority passed in here was sufficient if it actually was supposed to change the Constitution or override the Constitution to give it that teeth. That's a simple.
No. You go out. You're wrong, but go out.
As I tell you, sir, I got to keep watching. I don't know what's going to happen next. So having taken all of that into consideration, sir, and I being one of the people who has actually looked at some of the decisions in the granting of bail to say, how did you ever get...
What's the point of order, Honourable Member?
Is the Honourable Member telling this Parliament that All right. I wanted to correct him. I wanted
There's
to
no
correct him.
honorable.
Leave him and the Attorney General who he's advising.
Continue, honorable.
I remember when I came on my first day here, I was given a nice little book that had the standing orders of the House, explain what the points of order were, how to raise and do them. I read it back to front, which is why you can get them object sometimes to the honorable leader. I, not speaking to anybody, sir, but I do believe that we probably all should just read it again and just make ourselves familiar. Because what goes on here is televised, and I would like to portray Parliament in a good light. As I was saying, sir, myself being one of those people, and I'm a lawyer, myself being one of those people who said, I cannot believe this person got bail. Myself being one of those people who has said in the commission of offenses, that person should never get bail in Barbados. Myself being one of the people to whom the public comes, and they come to all of us to say, what are you all doing? What's the court doing in granting bail to these people? They're coming out and they're committing the same offense over and over and over. You all need to do something. Well, sir, we did it in this piece of legislation. We did it in this piece of legislation. And I am convinced that this is the best that we can do in these circumstances. I also want to commend the drafters. I want to commend the Honourable Attorney General. I want to commend him, sir, because it was no mean feat to get this here in the time that we did it. We had to sideline a number of things. We had to give priority in the drafting to this piece of legislation. And for us to get this to deal with a situation that is current in Barbados, a situation that begs to be dealt with, a situation that the Honourable Leader of the Opposition has begged us to deal with, a situation that we of our own know we must deal with. And sir, I am happy to support this bail legislation in providing a solution and forcing the courts to make the right decisions with respect to bail for accused, decisions that serve the interests of Barbados and promote faith in our criminal justice system, promote faith in our judiciary, sir, and give us comfort when we sleep in our beds at night that the best that could be done was indeed done. I thank you, sir.
Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move the suspension of the House until 3:30 p.m.
Made a second.
The question is that this honourable chairman be suspended until 3:30 p.m. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honourable chairman stands suspended until 3:30 p.m.